Yes, for the list.
Item number 1.
Now, my lord, we have a bunch of all the orders, my lord. I just want my lord to have a look at, my lord, all the orders. My lord, I've also prepared, my lord, a small written notes at the beginning. My lord can ignore that and just come to the orders which were subsisting in this writ petition. Then, my lord, I'll show the last order. We were on that occasion. And, my lord, that judgment, my lord, I've also considered. I'm sure, my lord, has also seen, my lord, that judgment was clarified by the same bench. Again, my lord, subsequently, my lord, has which my lord spoke about that factually it may be different. Because here, my lord, I just wanted to show, my lord, factually it's different. My lord,
Point it is very short that once charge sheet is filed, cognizance is taken.
no writ petition is
No writ
correct.
petition.
Well, Lord, in this case, there were orders prohibiting the filing of charge sheet and taking of cognizance.
No.
Before, in that case, my lord, there was no.
Mr. Banerjee,
Lord,
that's why court asked for if you come to the report of
my lord,
CBI.
I shall, my lord, just kindly give me 2 minutes today, my lord, just 2 minutes. My lord, kindly see the first order which is subsisting in the writ petition. My lord, page 1 is the order. This is, my lord, subsisting, my lord, from 16 March 2012. And if my lord cannot read this, then, my lord, I have a typed copy also.
No, it is readable.
Very well. Then kindly come to, my lord, page 4, page 7 is, my lord, the operative portion. My lord can just have a look, my lord, from page 6.
And
First order, 16 March 2012.
it is
My lord, has
reading
that, my lord?
from
Order.
Yes, page 6.
Page 6. And this is answers to discuss. Then, my lord, page 7.
Yes.
Above said principle laws repeated and honorable Supreme. View of the submission made by Mr. Day with regard to the verification of case, find the standard difficult. And observe herein above that the name of one of the suspected accused of one Aspire employee Eastern Railway is disclosed till date. Name of no other officer employee South Eastern Railway is mentioned in the said FIR. Balance of convenience or inconvenience is in favor of granting limited release to the petitioners. Since the investigation at a very early stage, in this case, I'm inclined to pass a blanket. Should be not inclined to pass a blanket order restraining order at this stage.
It should be. I'm not inclined to.
I should be not. I think, Mullah, because the concerned officers of the respondent 2 will be at liberty to proceed with the investigation under reference, but they are restrained from submitting any charge sheet. Final reports, as the case may be in this case, without the leave of the court.
This is an interim order.
This is an interim order.
Yes.
And then, Mullah, it went up to the Honorable Supreme Court also.
But it is interim order.
It is interim, correct,
Yes.
correct. Then let it be further recorded.
Flag down,
Separate forum for preventing the respondent from taking. Mullah, this is very important. Cause against them in course of conduct the situation so warrants. Then, Mullah, kindly come to.
So you are harping on this that no charge sheet is to be filed.
Correct.
Yes.
Mullah, then the order got modified to say charge sheet is going to be filed before this court.
It says that the concerned officers.
That is one of the order.
Number 2 will be at liberty to proceed with the investigation under the reference, but they are restrained from submitting a charge sheet, final report,
correct.
as the case may be. In this case, without the leave of the court.
Now, Mullah, kindly come to.
The charge sheet filing was restrained. Yes.
It continues, Mullah. In fact, the order subsequently gets modified to say it will be filed before this court. And they went and filed it, Mullah, before the Mullah concerned court, and Mullah cognizance was taken. That's why, Mullah, this was taken. And I'll show Mullah everything. Just give me, Mullah, 3 or 4 orders. That's all Mullah needs to see. Then, Mullah, kindly come to Mullah, page 14, the very important order of the Honorable Supreme Court. So, Mullah, here, Mullah, will find Mullah, all these cases. Mullah, will see first page 14. Mullah, is the order of the Honorable Supreme Court. Mullah, my name appears. Rashmi Metallics Limited and another versus Union of India. This was a challenge, Mullah, to the circulars on the basis of which, Mullah, the FIR, Mullah, was lodged. Then, Mullah, kindly see page 15. First item, all these matters, Mullah, are stand now, Mullah, stayed by the Honorable Supreme Court, including their recovery proceeding, because their case was that, Mullah, there's a differential rate of, Mullah, freight for, Mullah, iron ore which is imported and iron ore, Mullah, which stays in the country. Or rather exported and which, Mullah, stays in the country. According to them, we, Mullah, did not export, but we showed, Mullah, them as a consumption within. That was their case.
It relates to calculation of rate.
That's right. So they had also filed a suit. We had filed a writ challenging the circular itself. All these issues, and Mullah, several parts of the country, Mullah, writs were filed. All these proceedings are now, Mullah, pending before the Honorable Supreme Court. This FIR arises from that. This FIR arises from that. Then Mulad, so page 15, 16, Mulad will find Mulad, everything is staged, including Mulad, kindly see page 17, Mulad, item 23, another Mulad writ.
Where is stay? So far Supreme Court is concerned, the proceeding which was directed to be initiated, but no charge sheet is to be filed, as it was directed.
No, not this proceeding. No.
That was
No, that was
to do
not
with
stay.
the criminal case.
Mulad, these are
investigation under reference, but proceed with the investigation, but not,
No.
but they are restrained from submitting any charge sheet.
that's the interim order which is subsisting.
Maybe in this case without any leave of them.
Correct.
Yes.
Correct. This is Mulad in this case. This is in this case. But what I'm showing, Mulad, is the main matter. The challenge to the circulars and the recovery suit by the railways are all stayed
That is
by the
beyond
Supreme
party.
Court. Yes, you have a Union of India. You're not aware. Union of India is also.
CBI is not a party.
Then Mulad, kindly come to
I want to
Page-
I want to know from you, Mr. Banerjee,
yes.
that whether this investigation was stayed,
No,
as it
that's
was
exactly.
directed with an interim order passed by the
Lord,
coordinate bench.
If it was stayed, Mulad, the first thing I would have said, Mulad, it was stayed. It's
Yes,
not stayed.
yes.
Correct. Mulad, let me Mulad try and Mulad put myself factually before my Lord. Then Mulad can I'm sure Mulad the law Mulad perhaps I'll be only be able to assist. My Lord knows much more on this Mulad subject. I'm just Mulad trying to assist my Lord. Mulad, kindly come to Mulad page 18. Mulad, another order of the Honorable Supreme Court.
If investigation is impacted by subsequent order of the Honorable Supreme Court, show me.
Yes, I will show that.
That
It is.
should
It
be
is,
the
it is.
query so far this court is
Page-
concerned at this stage. Nothing more than that.
Mulad, page 26, 28 April 2017. Mulad, this is arising out of the writ which is before my Lord. Now, Mulad, this was filed. Then, Mulad, kindly see.
So the charge sheet was permitted to be
Permitted.
filed.
Yes. Then, Mulad, kindly
Charge
see.
sheet was permitted to be filed before the concerned court,
Yes. Mulad, this is an order of
Consent court.
16
meaning thereby
May.
CBI designated court.
Now, Mulad, kindly look at page 33. This order got recalled. That was, Mulad, an ex-party order at the instance, Mulad, of the union. Now, Mulad, kindly see page 33. After recalling a previous order.
Just a minute.
Sorry.
This is the order dated 27th August 2018.
Yes. Order dated 16 March, Mulad, is what I showed.
Just a minute.
So that order was recalled, that Mulad to file before the concerned court.
Just a minute.
Sorry. In fact, Mulad will find Mulad on the
Just. Whether the 16 March order was the final order on the writ petition.
that was what was passed, Mulad.
That writ petition was disposed of. No, that is still pending.
That is still pending.
But no, this has been held that this is a final.
In the nature of a final order. Because Mulad, the writ has to be heard really. And Mulad, just one thing.
So formal permission of High Court was required.
And it was taken.
And my lord, may I just,
But that is the part of this order.
that's
Yes.
right, my lord. No, formal permission, my lord.
Yes.
Sorry, my lord.
Yes,
It means
come
it
to
really
the-
has to be heard. That's it was
Yes,
cancelled.
yes.
My lord, may I just take 1 minute on
Set aside
this?
the cognizance order
Well,
and direct the appellants to go back to the High Court and
Yes.
apprise it
Correct,
of
correct.
the
We are on that.
that the charge sheet has since been filed and get permission for formally filing the same.
No, we set
So
aside the
filing
cognizance.
of charge sheet was not interfered with.
No, it was. We set
Banerjee.
aside the cognizance.
No, cognizance taken under section 190 of CRPC that
Set
was set aside. But filing of charge sheet under
Charge sheet has
section
been filed and
173.
cognizance order issued.
Yes,
Despite
yes.
this order.
There are two stages. First, charge sheet is to be filed then under section 173, then CRPC,
My lord,
and then under section 190, cognizance is to be taken.
before that, my
The
lord,
cognizance taking order by the court below was interfered with, but filing of charge sheet was not interfered.
my lord, filing
Only
of,
formal permission was.
my lord, the charge sheet has to come before my lord. Charge sheet has to come before my lord. Then, my lord, if my lord thinks, my lord will give them permission. First, my lord, it is to come back before my lord. This is, my lord, what we are on. This interim order which we now have,
Yes, yes.
my lord, may I just,
Then what is your
my lord, just
submission?
kindly
Yes.
look at, my lord, 26, my lord, saw, my lord, that 20. This is the order pursuant to which, my lord, they had filed the charge sheet and cognizance taken. This was, my lord, 28 is, my lord, the lower court order.
Then the order dated 27 September 2022.
Then 30,
Page
page 30,
35.
page 30, page 30, my lord, is
Just a minute. CBI is at
30 is ex parte order is recalled, and then page 33.
Yes, that is
And
on this writ petition.
Now, my lord, now kindly come to page 35.
That is
This is the order which we are paid for recalling.
34 of
35 of sale. Now, very important, my lord, kindly first find, my lord, can 3. My lord, is can 3. My lord, at the top, my lord, will find, my lord, old numbers are not found. Not found, my lord, on there. And then, learned advocate on the behalf of CBI paid for leave to file report in final form, CS after completion investigation. Leave is granted, CBI liberty to file charge sheet after submission a copy of the charge sheet along with all documents. Learned advocate petitioner, CBI would submit the charge sheet within the adjourned date. Accordingly, can 3 is disposed of. So, can 3 not found, but my lord, disposed of.
yes.
And can 3, my lord, was their application, which that's why, my lord, I said it has to be heard. I'm not, my lord, shying away, my lord, from having the matter heard. Then, my lord, this was the,
Now let us come to the report of the CBI.
my lord, now, my lord, may I just show, my lord, just another thing. My lord, all the orders are here.
Just a minute, I have forgotten this report.
Oh, I'm sorry, my lord.
After completion of the- Mr. Banerjee, please come to the report of.
Yes, yes.
First page, paragraph 3. That after completion of investigation of the case, CBI can so and so before the Honorable High Court,
Page 3, my lord.
praying for
Paragraph.
paragraph 3, page 1.
Yes.
Rather second page, not
Yes.
page. That after completion of investigation, the case CBI can number so and so before the High Court of Calcutta, praying for grant of leave for filing a report in the form under section so and so, which the Honorable Court, with the order dated 28 April 2017, granted permission. Central Bureau of Investigation to file supplementary affidavit in the writ petition, including proposed charge sheet and memo.
That's one of the order of,
Then the agree, that agree from the said order of the Honorable High Court of Calcutta on 28 April, CBI filed special writ petition.
correct.
So and so. The Honorable Supreme Court of India, order dated 16th May.
That is one that I showed at page, which was recalled.
Permission to CBI to file charge sheet.
Yes.
Yes, that is
That is at page 30. Sorry, page
26.
26, correct. I'm sorry. Yes, grateful. 26.
16th May. 16th May granted permission to file, granted permission. Just a minute. CBI filed agreed from the order. Central Bureau of Investigation, including proposed charge sheet and memo of evidence. Then granted permission to CBI to file charge sheet in the instant case and also ordered, if the respondents are agreed, liberty is granted to them to move this court. Accordingly, in pursuant to the said order, the Honorable Apex Court, CBI filed charge sheet before the Learned Trial Court on 28 May 2018. And Learned Trial Court took cognizance of the matter on 4th June 2018. This cognizance taken was set aside
This was recalled. The order was recalled.
by the Supreme Court.
And Supreme Court's entire order was recalled.
No, not the
Yes,
entire
yes.
order. No.
Yes, Mullah.
Let us come to
Factually,
this
Mullah, let us follow,
order.
not Mullah.
Page 33.
No, Mullah, page 29 and 30.
Please come to page
No, Mullah,
33.
kindly come to page 30 first.
Charge sheet has been filed and
Mullah.
cognizance order issued. Despite this order, we set aside cognizance order and direct the appellants to go back to the High Court and apprise it. We set aside the cognizance order
Mullah, kindly come to page 30
and
first.
direct the appellants to go back to the High Court and apprise it of the fact that charge sheet has since been filed and get permission for formally filing this.
Mullah, page 30. Page 30. Addiction. Page 30. Is recalled. Entire order is recalled. That page 26, Mullah, was recalled.
No, but subsequently this order, 27th August,
Yes. It said follow the drill, which means, Mullah, he has to come before the High Court.
first it was recalled
Correct.
and then this order has to be considered.
Yes.
Charge sheet has been filed and cognizance order issued. Despite this order, we set aside the cognizance order and direct the appellants to go back to High Court and apprise it of the fact that charge sheet has since been filed and
get permission
for
formally filing
the
the
Yes.
That's right. That's
That
Mullah,
is the
where-
final
Correct.
order so far Supreme Court is
Correct.
concerned with regard to filing of charge
Correct.
sheet.
So, Mullah, we are now on the question because Mullah told me that
Now, therefore, as on date, Mr.
Yes.
Bandyopadhyay, charge sheet filed and filing of charge sheet is not interfered with. Only cognizance taken was interfered with.
no, Mullah,
Yes.
follow the first language is Mullah.
Yes.
Passed by the final order.
Because
is that-
court has to go by the order dated 27th August 2026.
That's right. That's what I'm saying.
27th August 2018.
No, Mullah, kindly say this being the case, the drill of the said order has to be followed
Just a minute. Then, yes, come to their
before the High Court. Charge
That
sheet
in
has to be filed before the High
come to
Court.
the report that in compliance with the order of the paragraph 6, that in compliance with the order of the Honorable Apex Court dated 27th August 2018. I am on 27th August 2018 order,
Yes.
where filing of charge sheet was not interfered with, but cognizance was interfered with, and mere a formality, a permission was required to be sought for from the Honorable High Court. Please, paragraph 6.
Mullah, may
That
I
in
just make one
compliance-
submission?
Please, allow me to understand what is your case. That in compliance with the order of the Honorable Apex Court dated 27th August 2018, CBI approached the High Court of Calcutta by filing CAN so of 2018 for granting permission to file charge sheet. The Honorable High Court, Calcutta video order dated 27th September 2022, granted permission to file charge sheet in the case by submitting a copy of charge sheet along with copies of document to the advocate of petitioner. Then the CBI
No, this is-
resubmitted charge sheet on 18th March 2023 before the learned special judge CBI court, Kolkata, Reshmi Metallic Swanso, and 1988 Swanso under 1988 Act. The petitioner, that is Mrs. Swanso, again approached Honorable High Court of Calcutta by filing CRR against filing of charge sheet and cognizance taken by the Learned Trial Court. Honorable High Court of Calcutta dismissed CRR as there was no infirmity in filing charge sheet and cognizance taken by the Learned Court. The said petitioner simultaneously filed CAN in High Court Calcutta Swanso. Now, show me the order passed in
I
CRR
shall.
1112.
Mullah, in the report, what is wrong is
Show me the order passed by.
it is here. Mullah,
Please show me.
27.
First, show me, I will hear you. Show me that order passed in the CRR.
Mullah, it's at page.
Please show me.
Yes, I am going to show Mullah. It's
Yes.
not that Mullah.
Yes, please.
Mullah, page 37.
37.
Page 37.
Yes.
I don't know why Mullah is getting. Of course, Mullah, I'll show Mullah. It's not a question of Mullah not showing the facts.
Hmm.
Law Mullah will follow after that. And Malad, just Malad, read page 41, Malad, then Malad comes to page 40.
Just a minute.
Look, can you read it, but can you read page
No,
41?
no,
Malad?
let me go through this.
Yes, yes, please go through the whole order.
Yes. According to CBI. Hmm. Now, have you preferred appeal against this order dated 24th March 2023, Mr. Banerjee?
So now, Malad, may I make my submission? May I make my
No,
submission?
please, I want answer.
No. If I done, I would have said so. So now may I make my submission?
Yes.
Malad, kindly come to page 41 of this order. This Malad is read. Kindly come to page 41.
Yes.
41
Yes.
says it was submitted on behalf of the petitioners. In the middle, Malad will find it was submitted on behalf of the petitioners that this court in WPA number 4652 of 2012 restrained the CBI to file charge sheet, final report as the case may be without the leave of the court. Instead of that, CBI submitted charge sheet to the learned trial court, upon which the learned trial judge took cognizance of it and issued process against the accused person. A coordinate bench fixed 12th April 2023. This order, Malad, is of Malad 24th March 2024. 12th April 2024 for hearing of an application being Can 4 of 2023 arising out of WPA number 4652 of 2012. Now this, and Malad, also page 42. 43.
Accordingly, CBI
The said,
filed.
no, just before that, Malad,
Page 43, come to page 43.
Yes.
Accordingly, CBI
CBI
filed charge sheet
correct.
in the trial court on the basis of leave granted in WPA 4652.
Yes, very important. 27th September 2022.
Thus, the Honorable Supreme Court
Direction effect drill has to be followed was successfully complied with.
direction to the effect that the drill of the said order has to be followed was
Moreover-
substantially complied with by the petitioners.
Now, Malad, may I
Moreover,
just-
the petitioners have prayed for quashing, setting aside of the order dated 18 March 2023 passed by the learned
Learned
judge
judge
Swanso, Calcutta on the
This is the
basis
order
of the
dated-
order dated 16 March 2012 passed
asking WPA number, the said WPA, this is this list,
is pending before the coordinate bench.
said
The
bench
state
granted
bench granted
leave to the CBI to file charge sheet. Accordingly, charge sheet was
Accordingly,
filed
charge sheet has
Cognizance of
filed,
offence.
cognizance of offence was
in view of such circumstances.
taken and notice was issued against the petitioners. In view of such circumstances, I do not find any merit In the instant revision, no order was passed. No order passed by either High Court or Supreme Court was disobeyed by trial judge.
Malad, this order is subsequent to the order. Malad, the order date, Malad, can you see? 24th March.
This is end of this matter.
No. Malad, this is subsequently passed.
Yes, yes.
Can you Malad, look at the other order of 24th March?
Page 44.
Page 44. By this time, Malad, 27th September has been stayed by the same judge. Can you see can 4? This is referred to in the other order. Learned advocate for the petitioner submits that this court directed CBI to file charge sheet been determined that is before November 24th at this court. Instead of that, CBI has submitted charge sheet to the trial court.
I will modify this order on the basis of the order passed by the Honorable Supreme Court.
No, Malad has to hear me. Can you hear can 4?
Yes, yes.
Can you hear can 4?
No, it's not required at all after filing of charge sheet.
Malad, that is Malad the order. Malad, I want to also Malad show that judgment. Malad is not hearing me, Malad. Malad, can you Malad look at Malad page 44? Malad, this order has been there for some time. And there's a reason why that order has been there. Malad, there's a reason why that order has been there. Kindly do not Malad take us amiss. Malad, page 45.
No, question of taking you amiss does not arise.
Malad, page
You are here
45.
to talk law on behalf of your client. Why I will take you amiss?
Malad, kindly look at page 45. Kindly look at page 45. Page 45. Learned advocate for the British Service Court answer. Instead of the CBI.
Mr. Banerjee, the order passed by the Supreme Court is very clear. So therefore, yes.
So they could not have filed. My lord, I perfectly understand. My lord, here's out can 4.
Charge sheet has been filed and cognizance order issued despite this order. We set aside the cognizance order and direct the appellants to go back to High Court and apprise it.
Yes,
of the
for
fact
filing charge sheet.
That a charge sheet has since been filed and get permission for formally
Correct.
filing the
Correct.
And that is.
And that is not given.
Therefore,
That is not given.
No. Honorable Supreme Court did not nowhere said that filing of charge sheet has to be before this court.
Well, that's what the Supreme Court says.
Has to, and not only this,
16 March.
there is an imprimatur. So for the criminal divisional.
Well, it's 16 March.
Yes, Esho.
Well, it's 16 March is there.
Matter is heard in.
Well, I don't know
presence of
what.
the
Well,
learned senior matter is heard in presence of the learned advocates representing the petitioner and Central Bureau of Investigation.
Your Lordship, may I just make one small little submission? I'm sorry
Yes.
to
Required, I have heard, enough is enough. Central Bureau of Investigation.
Your Lordship, may I just for 1 second,
By,
Mr. Luthra would
Mr.
like to
Banerjee,
supplement.
Mr. Ragnanko Banerjee, learned senior advocate representing the petitioner, prays for extension of interim order. In view, prays for extension of interim order.
Your Lordship, Mr. Luthra would like to
Passed
supplement
earlier on this
what.
petition.
Your Lordship, at least give me one.
Initially passed on 16 March.
16 March.
Prays for extension of interim order.
My lord is extending my lord the order of 24th March 2023. Page.
By Justice Samantu.
Yes. Page 44.
Because
And
that order, by flux of time and by virtue of several orders passed, got modified.
No. My lord, what happened? Just one submission, then my lord can come. I'm sorry, my lord. 16 March, my lord, has seen. My lord, according to us, my lord, it was to be filed, my lord, before the High Court. And my lord, then the High Court would decide, my lord, whether permission should be given or not. Instead of that, in the order of 27 September 2022, though my lord, the language is before this court, but they went and filed, my lord, before the trial court. That's why my lord, cognizance was taken. We came back and applied before this court.
Then on CAN 4,
That's right.
this order was passed that it is to be filed before this court. That's how this order can survive in view of the order passed by the Supreme Court on 27th August 2018. There is no rider, Mr. Bandyopadhyay. Mr. Banerjee, please come to page 33 again.
Yes, my lord.
Charge sheet has been filed and
My lord,
cognizance
before that,
order
since
issued.
my lord is giving me so much
Despite this
indulgence, my
order,
lord,
we set aside the cognizance order and direct the appellants to go back to High Court and apprise it of the fact that the charge sheet has since been filed and get permission for formally filing the same.
well, it's just before that.
But there is no fetter. So for filing of charge sheet before the CBI court,
Well, that, well, may I just
there
show
is
the
no fetter.
first line of the order of that same order, page 33. first line of the, just I'm sorry, since Mullard has given me this indulgence, but that's his first line. We have been shown the fact that the order dated 16 March 2012 passed by the High Court final order, in that appellant has not filed an appeal challenge. That being the case, drill of the said order has to be followed.
And that is the
Drill has to be followed.
and that is the clarification given.
And no.
এসো মিস্টার
Mullard,
এটা লিখো না
Your Lordship,
মিস্টার বন্দ্যোপাধ্যায় is very
Mullard,
competent counsel, and if I permit him
no,
he will
Mullard,
continue
kindly do
throughout
not
the
say
day.
that. Mullard, kindly do not say
That
that.
I know.
Mullard, just one more order. Mullard, this order,
further.
Mullard, this one.
Matter is কি বলছিলাম?
Mullard, this order has been also Mullard considered. Mullard, page 25, Mullard, Justice Bakchi's orders there.
Stop. না কি আরেকবার সেন্টেন্সটা বলো।
Your Lordship, Mr. Luthra needs to supplement some arguments and he's out of country. So therefore, I am seeking short indulgence. He would only supplement what Mr. Banerjee has argued for.
Extension passed earlier on 24th March 2023.
Your Lordship may give me some indulgence.
It is submitted on behalf of petitioner that in primarily an order was passed on 16 March 2012 on the writ petition by a coordinate bench. Stop. By the said order dated 16 March 2012, CBI was granted liberty to proceed with the investigation under reference, but they were restrained from submitting any charge sheet, final report, as the case may be. But they were restrained from submitting any charge sheet / final report, as the case may be, without leave of the court. Stop. Issue traveled before the Honorable Supreme Court, and an order was passed on 27th August 2018 on special leave petition within bracket criminal number 4654 of 2018. Stop. Relevant part of the said order of the Honorable Supreme Court dated 27th August 2018 is 2018 runs infra. এই দেখো প্যারাগ্রাফ 33 টাকে কোট করে দেব, পেজ 33 এই পোর্শনটা কোট করে দেব। Next paragraph. Vide said order dated 27th August 2018 Honorable Supreme Court, based on submission made on behalf of CBI, held observed decided to set aside order of CBI court, thereby taking cognizance of offense, and also directed প্রথমটা CBI করে সেন্ট্রাল ব্যুরো অফ ইনভেস্টিগেশন করে within bracket for short CBI করে, and directed CBI to go back to High Court and apprise it of the fact that charge sheet has since been filed to take permission for filing of said charge sheet. Stop. Pursuant to the said order dated 27th August 2018, CBI filed one application being CAN 10026 of 2018, thereby sought for permission to file charge sheet.
Not found, Malad. That was not there, Malad, before.
A coordinate bench, while disposing of the application of petitioner, application of CBI, permitted CBI to file charge sheet. Stop. Vide said order dated 27 September 2022, CBI was also directed to serve copy of charge sheet along with all documents to the learned advocate for the petition. Not, sir. Stop.
Submission was
Next paragraph. Subsequently, CBI resubmitted charge sheet on 18th March 2023 before the learned special judge, CBI cases based on which trial court took cognizance of offense. Stop. Or based on which trial the court took cognizance of offense. Stop. Next paragraph. writ petitioner filed or preferred one criminal revisional application being CRR 1112 of 2023 within bracket Messrs Reshmi Metallics Limited and others versus Central Bureau of Investigation, comma Anti-Corruption Branch, comma Kolkata. Full stop দেবেন না questioning order dated 18 March 2023 না order dated 18 March 2023 passed by learned judge within bracket in charge close bracket special within bracket CBI close bracket special তারপরে within bracket CBI close bracket court number 1 comma Calcutta in special CBI case number in special CBI within bracket case number 02 of 2018. Stop. While dismissing aforesaid criminal revisional application, coordinate bench passed following order. Page 43 of compilation, ডাক দিয়ে দিচ্ছি ওইভাবে করে দিল সেট আউট করবে
Just one thing. Page 44 Mullet is prior to Mullet page 37.
Next, from the relevant part of the order of the coordinate bench, dated 24th March 2023, it transpires that challenge thrown by the present petitioner against filing of charge sheet before the CBI designated court was not interfered with, and it was recorded in the said order that charge sheet was filed and cognizance of offense was taken. And notice was issued to the petitioners. Stop. Next paragraph. It has been strenuously argued on behalf of petitioner that order passed by the coordinate bench while disposing of criminal revisional application on 24th March 2023 was based on order
Page 44.
Dated 27th September 2022, page 35.
এখন যাবো না।
No, my lord. Yes, 35, 27. Sir. No, I'm not saying that, my lord. My submission is, my lord, it's after 44. I'm sorry, my lord. I'm sorry, my lord.
Based on order dated, based on, কি বললো?
Yes, correct.
27th September 2022, passed by a coordinate bench on the writ petition, thereby granting liberty to CBI to file charge sheet after submission of copy of the charge sheet along with all documents to the learned advocate for the petition. Stop. According to the petitioner, on 24th March 2023, another order was passed by the coordinate bench on the writ petition and connected application being Can 4 of 2023.
I'm great. In fact, this was prior to, my lord, the same.
Thereby, the fact was taken into consideration that charge sheet was filed by CBI before the CBI court and not before the High Court. And consequently, operation of charge sheet submitted by CBI on 18 March 2023 was stayed. Stop. Next question. Considering chronology of facts and orders passed by different courts, including the Honorable Supreme Court from time to time, this court needs to consider the order passed by the Honorable Supreme Court on 27th August 2018. Wherein Honorable Supreme Court granted liberty to CBI to obtain a formal permission for filing formal permission with regard to filing of charge sheet, and cognizance of offence was, and the order by which cognizance of offence was taken was set aside. Stop. Next paragraph, taking note of the order of the Honorable Supreme Court dated 27th August 2018 and subsequent order passed by the Honorable passed by a coordinate bench on 24th March 2023 on criminal revisional application, wherein challenge was thrown by the present petitioner whereby বাকিটা কেটে দাও, whereby পরে বাকিটা কেটে দাও, whereby filing of charge sheet by CBI was questioned, comma, today this court does not find any impediment to permit the does not find any impediment in permitting the CBI to take steps accordingly based on filing of based on filing of charge sheet on 18th March
2023.
2023.
2023. Stop. Order passed by the coordinate bench on 24th March 2023 on the on Can 4 of 2023 is modified on the strength of in consideration of the order passed by the Honorable Supreme Court on 27th August 2018, semicolon, as per said order dated 27th August 2018 of the Honorable Supreme Court, a formal permission was required to be obtained it needs to be recorded herein the order passed by the a coordinate passed by the coordinate bench on criminal revisional application on 24th March 2023 attained finality, since it is submitted on behalf of petitioner that said order dated 24th March 2023 was not assailed by preferring appeal. Stop. Next paragraph. In view of aforesaid discussion, it appears that charge sheet was filed on 18th March 2023. and subsequently cognizance of offence was taken. Next paragraph. Next challenge might have been thrown by the petitioner questioning steps taken by the CBI relating to filing of charge sheet. But in view of the judgment of the Honorable Supreme Court reported in 2024 SCC Online SC 5761 within bracket Neeta Singh and others versus State of Uttar Pradesh and others, writ petition is not maintainable after filing of charge sheet and taking cognizance of offence. Stop. This court is not considering a petition under Article 227 of Constitution, neither a petition under Section 482 CRPC / 528 BNSS. Stop. Once judicial order has intervened in the proceeding, which such steps received imprimatur by virtue of order passed by coordinate bench. Dated 24th March 2023, passed on criminal revisional application, which has attained finality. Present writ petition is not maintainable. Stop. Hence, the writ petition stands disposed of, permitting the CBI to take steps in accordance with law. Stop. However, this order shall not preclude the petitioner to take steps in accordance with law.
But since there was an interim order subsisting order, I was praying for a stay of the order.
Yes.
But since there was an interim order subsisting order, I was praying for a stay of the order.
Mr. Banerjee, learned senior advocate representing the petitioner, prays for stay of operation of this order, which is opposed by Miss Alam, learned advocate representing CBI. Stop. Such prayer made on behalf of petitioner is considered and rejected. Stop. Parties to act on server copy.
Great. Well, the orders and all that, with the notes, we have also filed.
Yes, yes.
Well, that orders, bunch of
Compilation,
and
yes.
the notes, there's notes also, which is there.
একদম উপরে দিয়ে দাও। Compilation filed on behalf of written notes filed on behalf of petitioner. Is taken on উপরে দিলা একদম top. Whether any applications are pending?
All applications.
All applications are pending. Applications, if any pending, are also disposed of.
Great.
দেখি ওই অর্ডারটা চলে গেল কিনা। দাও 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 সেটটা দাও, হ্যাঁ ওটা দাও। এটা তুমি ছবি তুলে নিয়ে যাও দরকার পড়লে। নিতেছি আছে তো।
Item number 2, My lord, I am appearing for the petitioner. Lordship kindly goes to the Lordship's order dated 24th of June 2026. My lord, more specifically paragraph number 5, my lord, of your Lordship's order.
Paragraph?
5, my lord, of your Lordship's order, my lord, last order.
Lordship, in all the 10 cases, final report has been filed with mistake of final report, mistake of fact. All these 10.
Just a minute, let me- Yes, reports, you are filing today report.
Yes, this is the report, Lordship. All 10 cases have ended in a final report
May I have a copy? of the
disclosing
report?
mistake of fact. Yes.
Proven.
Question of us.
Mistake of fact. It's a FRT5.
FRF.
Mistake, FRA.
FRMF.
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 Mistake of fact.
Final report, mistake of fact.
Yes, my lord.
So recording this, let me dispose of the
Yes,
requisition.
my lord. It is filed before the courts below, my lord, may also record it. It's filed, my lord. That word is not there. That is what I'm indicated. The file.
Hmm. It has been filed before the
Well,
learned court
that's
below.
it. That may be recorded as a submission and Lordship can dispose it of.
Issue. Pursuant to the order dated 24 June 2026. The report is filed by the Commissioner of Police, Barrackpur. Dated 26th August 2026 and same is taken on record. Copy of the report dated 26th August 2026 is made over to learned advocate representing petitioner. Next slide. Mr. Sujanil Das, learned advocate representing petitioner, submits that on completion of investigations in 10 criminal prosecutions which were pending against the which are pending against the petitioner. quote unquote final report mistake of fact within bracket FRMF close bracket unquote. Was filed in respect of all the criminal prosecutions before court below. Next paragraph. In view of filing FRMF in all 10 criminal prosecutions which were pending against the petitioner, no further order need be passed on this writ petition and the writ petition is disposed of. The parties to act on server copy.
Deeply.
এইটা এর সঙ্গে ট্যাগ করে রেখে দেব দিয়ে দিচ্ছি
Item number 3.
Now for the petitioner, my lord. My lord, in the order dated 18th August,
yes
at the paragraph number 1, the premises number has been erroneously recorded as 47. It will be 41, man.
do you have the copy of the report communication which was filed by the on behalf of police authority?
My lord. Right now, I don't have, man.
This is dated 23rd July 2026. Come to third page, fourth page of this report,
Fourth page, my lord. The fourth page.
paragraph 7.
Paragraph 7.
Read it. So far, other issue is concerned regarding alleged obstruction on the public footpath in front of mentioned premises of 10th missionary. It was found two temporary structures so and so shall exist on footpath in front of 47 10th mission,
Mission Road.
not 41.
My instruction is the premise.
Where is that? This is the report of the police authority. (47) mission.
On the public footpath adjoining the front ground.
Then matter needs to be heard again. Because taking note of this, this order was passed. Then a separate report is required to be called for. Then I'll recall my order.
Premises number
I will not allow all to make
Well,
submission.
My lord.
This is
sorry,
not your drawing room.
My lord, sorry. Premises number has been is reflected as 41, my lord. The in front of boundary wall of
47, paragraph 7. I have followed it.
flower to flower 20 and
those are the flower shops and the
That
chicken.
I do not know.
another
It is specifically stated 47. Flower stall and chicken stall exist on the footpath in front of 47. And I remember flower stall and flower stall and chicken stall were removed. But there was one permanent brick and mortar structure that you prayed for removal.
Yes, yes.
Court directed to take steps. Now, considering this aspect, I recorded in my order that it was the premises in question is 47 Den Mission Road.
In the last line, my lord, the public
If
footpath.
you want, then file an application, serve a copy upon them, pray for modification of the order. Because considering this report of the police authority, I passed order.
Mal,
That will not be corrected in such a manner.
mal.
If
Right.
required, court will pass further direction upon the police authority to cause inspection and to find out what is the appropriate number of the premises in question.
Mal.
Yesho,
Modification. Application file.
matter is accommodated in today's list under the heading to be mentioned for correction of order dated 18th August 2026. When prayer is made for correction of premises number in question as mentioned in paragraph 1 of the said order. Stop. However, on perusal of the communication filed on behalf of police authority dated 23rd July 2026, it appears in paragraph 7 of said communication, it was mentioned, in paragraph 7 of the said communication, number of premises was mentioned as 47 Dent Mission Road. Stop. Hence, prayer for correction of the order dated 18th August 2026 is refused. However, petitioner shall be at liberty to take steps in accordance with law, if so advised. Stop.
Item number 4.
The paragraph 2 is absolutely correct. It is title suit, but the paragraph 2, where it has been mentioned as title suit number 137, it is absolutely correct, my lord. But kindly comes to paragraph number 4. The FIR number has been mentioned as 137 Fulbagan PS. That would have been 136.
Title suit number 137.
That is correct. That is correct.
But Fulbagan police station case number
136.
Yes.
It will be 136.
I have got the FIR copies also, my lord. The cases are different.
Come to the report of the police.
That I do
But
not
in
have.
the report, well, it is 137.
Yes,
And my lord,
there is no departure so far this court is concerned.
No, my lord.
I
Yes,
minutely
I bow down
verify
to
this.
no, my lord, in the report, my lord, it is my lord 137.
Have you stated in your writ petition?
that is after effect.
Then how I can do this?
My lord, kindly peruse the FIR copies, my lord. I have got the FIR
No,
copies.
in that event you have to make an application.
My lord,
In the communication dated 29 July 2026 of
Police.
officer in charge Fulbagan police station, page 2, first paragraph, it was stated Fulbagan police
137.
station case number
137.
there is a mistake on the part of the police, my lord. I have got. But then, madam, I call for a report now also, my lord.
No. This is a disposed of matter.
But 2.5
I can call. You have to file an application
The
for
3 weeks I
modification.
am roaming around, my lord. The
Matter is accommodated in today's list under the heading to be mentioned for correction of order dated 6th August 2026. Stop. Learned advocate representing the petitioner submits that in paragraph 4 of the order dated 6th August 2026, FIR was a number of FIR was mentioned as Fulbagan police station case number 137 dated 22nd July 2026, quote unquote Fulbagan থেকে 22nd July 2026, and according to the petitioner it should be Fulbagan police station case number 136 dated 22nd July 2026. Stop. However, this next paragraph. However, this order was passed on 6th August 2026 after perusing communication of officer in charge Fulbagan police station dated 29 July 2026, wherein it was specifically stated that FIR was registered being Fulbagan police station case number 137 dated 22nd July 2026. 22nd July 2026. Stop. Next part. Stop. Hence, prayer for correction of order dated 6th August 2026 is refused. Taking note of contents of the communication dated 29 July 2026. Stop. However, petitioner is at liberty to take steps in accordance with law, if so advised.
Item number 5.
In item number 5, Lord, I beg to appear on behalf of the petitioner, my lord. In earlier occasion, my lord, the matter was taken up for hearing and direction to serve upon the meta, my lord, the respondent number 9, who is the one of the answering respondent. Now, my lord, we have attempted the service. Now, my lord, it has come returned by saying that no such person in the address. Then after, my lord, in earlier occasion, one advocate who was appearing for Meta, my lord, I have ascertained the new address, my lord, that has already been given. So, my lord, and they have instructed us to search through email, my lord.
I was still responsible. You could not serve.
Yes, my lord, we have attempted the service to the address, my lord. Then after I ascertain the new address, my lord, this I have to incorporate the new address and serve again, my lord. I have got the instruction for the particular advocate who was appearing earlier, my lord, for Meta, my lord. He said, my lord, kindly serve through email. He have provided me the email address also, my lord. So, my lord, if I serve by today itself through email, my lord, let the matter be appeared after 2 or 3 days, my lord. Then only it will be possible, my lord. Otherwise, we have
You could not
attempted.
serve upon respondent number 9 directly.
I have served, my lord. The address which was available in the website, my lord, I have served. Now it is returned back with a remark that no person is living in that area, my lord. So now, my lord,
There is no use of filing.
yes,
this.
my lord. So I have ascertained the
Yes,
new
sir.
address,
Yes,
my
sir.
lord.
At the time of call, learned advocate representing petitioner prays for accommodation to serve notice upon learned advocate representing respondent number 9. Who are the
I'm for the Union of,
state? All are representing
I'm
state.
Union of India.
State respondents and Union of India represented by learned advocates. Next part. Hearing of this matter stands adjourned as prayed for in order to enable the learned advocate for the petitioner to serve notice upon the learned advocate for respondent number 9. Stop. List the matter under the same heading for further consideration on. September 2026.
Grateful to your lordship.
Next,
My lord, on the instruction of the
let the matter be called on. Wait. It's
my lord, on the instruction of the advocate on record, Mr. Prithviraj Vishwas, I am praying for 1 day adjournment, my lord. He is unable to come to court.
accommodation is paid for on the previously adjournment was paid and that was granted. Again, court will not grant adjournment.
My lord, he is
There is
critically ill. My
my lord, to
Sorry.
to
lord,
investigate
kindly,
However,
the
it is
matter.
made clear that no further adjournment shall be granted on the next.
okay,
Very
my lord.
simple matter.
Yes,
Very simple matter, my lord. He has prayed for, my lord, for investigation.
for
For investigation, my lord, relationship in between.
already charge sheet filed.
My lord,
Kindly
my
take up
lord,
tomorrow, my lord.
my lord, we have
Already charge sheet filed.
we have registered the case, and my lord,
My
that is
lord, kindly take up tomorrow, my lord.
that is, my lord, investigation is going on.
My lord, kindly,
Investigation is going on.
Yes, my lord.
my lord, kindly
Accused
take up
person
tomorrow.
claimed
No,
herself as
sorry,
a
refused.
accused person claimed herself as a medical student. She wanted money. My lord, money was given through UPI system. Prayer is very simple. আরে দাঁড়ো হয়ে কি আছে তোমার প্রেয়ার তো হয়ে গেছে ইনভেস্টিগেশন অনলি ফর প্রপার ইনভেস্টিগেশন চেয়েছে যেটা এটা দেখা সবে তো না স্যার এটা নামটা ঠিক আছে তো কি কস্তব কান্তি নাকি শুধু কস্তব এই যে না যশোর কপি দিয়েছি তো ফর প্রপার ইনভেস্টিগেশন চেয়েছে ইনভেস্টিগেশন অলরেডি আচ্ছা দাঁড়া তো হয়ে গেছে ফোনে বলি কি বিরাট ভাবনা কি বিশাল একটা দেখুন কমপ্লেনটা আমাদের সঙ্গে অ্যানেক্সের কমপ্লেনটা নিয়ে যাও তোমার ওটাতে আছে আমাদের দিকে কমপ্লেন ধরে কত পেজ কত কমপ্লেন কমপ্লেন ধরে পেজ পেজ নাম্বার কত এর এই ছাব্বিশ পাঁচ এটা হচ্ছে মে লিগেল নাকি অল আর লিগেল করে ছেড়ে যাবে সব মিলে বলছি অল আর লিগেল
At the time of call, accommodation is paid for on behalf of petitioner, but same is refused since matter was previously taken up on 29 July 2026 when when similar prayer when prayer for adjournment was made on behalf of petitioner and same was granted. Thereby, same was granted. Stop. Video order dated 29 July 2026. Court directed the matter to be heard on 26th August 2026. Stop. Subsequently, 26th August 2026 was declared as holiday. As a result whereof, matter is taken up for consideration today, 27th August 2026. Next paragraph. From the learned advocate representing state respondents has filed a communication dated 26 July 2026 of officer in charge, Bardwan Police Station, and same is taken on record. Stop. Copy of the communication is made over to the learned advocate
Already I have.
representing the petition. Stop. Next paragraph. It is disclosed in the communication that based on complaint lodged by petitioner, one FIR was registered being Bardwan, not Bardwan. There is another police station. Yes. Bardwan Police Station case number 436/2026 dated 23rd July 2026. Under section 318 within bracket 4 of BNS 2023. Stop. It is also stated in the communication that investigation is going. Stop. In the said complaint, allegation is against respondent number 5. Next slide. In view of steps taken by the concerned police authorities, present writ petition is disposed of, thereby directing the investigating officer to expedite the investigation and submit report before the jurisdiction magistrate at an early date. Stop. Dispose of আগেই বলে দিলাম parties to act on server copy করে দেবে এই ম্যাটার গুলোতে আর xerox certificate copy দিচ্ছি না yes disposed of.
Item number 7.
For the petitioner, there was a direction by your lordship to serve the respondent number 7. We've caused fresh service. May I
Time for the state respondent.
service.
Yes, service
We served a fresh one.
upon whom? Respondent number
Number 7, which is the Central Bureau of Investigation. At page 11, your lordship will find the
non-appearing respondents are there. Only CBI was required to be served.
Only CBI is required to be served.
Then Enforcement Directorate,
They are not the relevant party.
but you have made them party.
I believe they were served. It was affidavit of service was filed on the previous occasion. Only
No.
respondent number 7 was.
Service was filed previously.
7 and 8.
Oh,
Please give it to
I'm
the learned
comfortable.
advocate. Show me that it was served upon ED. Who is appearing for CBI? Persistently, I have found that CBI is not being represented. In one matter, I had to direct learned ASG to appear.
So Amajit De, he is the standing counsel for.
Amajit De.
Amajit De.
এই নামটা লিখে রাখো তো অজিত দে
I can provide the number also if you want.
But the enforcement directorate was served on the previous occasion.
How? Show me.
But I'll just check just check the corresponding speed post entry.
Show me that ED all are served. Since you have made ED has to be served.
One of the page 6 of that. ED was
Where is the postal slip?
just before,
Corresponding postal slip?
just before that. Page 5. In fact, one of the endorsement as they
8-9, just a minute.
served at Bidhan Nagar.
I have informed him he is.
Delivered at Bidhan Nagar address him. CBI had refused. Bidhan Nagar would be the office address of the ED.
Delivered.
Subsequently, the CBI has also.
Delivered, 6-8-9.
The pages 11 and 12 are the service upon the Central Bureau of Investigation. Kindly comes to page 12, last entry.
Enforcement Directorate is 560. Just a minute.
That's the Bidhan Nagar address.
560.
Page 6, kindly see. Page 7, last entry.
Please place your case.
The petitioner was arrested, was a named accused in that infamous primary teacher recruitment scam. Pursuant to orders by this court, the petitioner was arrested and subsequently enlarged on bail on 10th November 2025. During the course of the investigation, the petitioner categorically made a representation to the Central Bureau of Investigation where he wanted to cooperate with the investigation and turn into an approver. Immediately upon that fact being known, certain members of the former ruling dispensation who were named, I can place that representation to you also. But there was a lot of people who turned up at the petitioner's house. The petitioner was
What you are praying for?
police protection.
Police protection?
Yes, there's a serious threat perception, my lords.
Already submitted a report. We are on constant vigil, my lord.
The constant vigil, my lord. I am a interested witness. Your lordship knows, my lord. I am entitled to certain protections, my lords. Prayer E, my lord, effectively that I am praying for. Kindly
Prayer E.
Prayer E, my lords. Sorry.
Does recruitment case again?
Sorry,
No.
to report a copy tag, but then I will get it. আপনি বোধহয় আমাকে copy করুন।
They need under a reserve of
If you don't mind.
Now you are accused in a proceeding, criminal
Proceeding
proceeding,
where
which is being investigated upon by CBI.
CBI.
Now what protection the police will give? You are an accused person.
No, my lord, I have desired to turn into an interested witness. That is expressed to the Central Bureau of Investigation, my lord, which is, I think the term is approver. My lord, under the witness protection scheme also, I am entitled to certain protection.
Now what are the incidents which
My lord,
prompted you to
kindly
approach this
sees
court
that
seeking for
kindly
protection?
sees the grievous nature of the scam. And the persons who were named by me and were sought to be named by me during the course of the investigation. Just few paragraphs, I'll just show 3 and 4 paragraphs. My lord, kindly first comes to the representation that I had made, which is at page 45. This was to the Commissioner of
What
Police.
is your instruction? Because prayer is made upon the for direction upon the police authorities to provide protection.
My lord,
CBI has no role to play so far this.
my lord,
matter is
we have
concerned.
already submitted a report, my lord.
Report?
Yes, my lord, on the other day, my lord.
No, that is not recorded. No report.
My lord, let it be, my lord.
And also it is not recorded in the order. Only CBI was not represented, matter was adjourned. Direct.
দিয়েছিলেন ওটা
মনে হয়।
হ্যান্ড ওভার পুলিশ অ্যাক্ট
There is no, you obtain instruction whether petitioner has expressed willingness to become approver. Because police authority is saying that there is no intimation from CBI. CBI or any other competent authority indicating that the petitioner has been accepted as an approver in order to cooperate in the investigation. Now he has changed his stance. If the stand is changed, now he is apprehending intimidation and threat by other persons.
that has already happened.
Other persons. So therefore, since police is not from the report, it appears that it is not affirmed or any intimation from CBI with regard to changing stand of the petitioner. You obtain an instruction and come back. Apprise this court with a short report. Issue. Affidavit of service filed on behalf of petitioner is taken on record. Stop. Petitioner prays for direction upon the concerned police authorities to provide protection.
আমি নিয়ে নিচ্ছি
Protection
আমি
since it is submitted that petitioner has decided to cooperate in the investigation relating to primary teachers recruitment scam. It is also submitted that petitioner was arrested by CBI and was subsequently enlarged on bail. Video order dated 12 November 2025 passed by this court in CRM within bracket M number 1325 of 2025. Stop. Stop. Next paragraph. However, it is disclosed in the communication dated 22nd July 2026 of officer in charge Soshuna police station that there is no intimation from CBI that petitioner will cooperate in the investigation and will become approver, quote unquote. Next paragraph. Learned advocate representing CBI is directed to obtain instruction. Now, concerned authority of CBI is directed to file a short report disclosing whether petitioner is cooperating with the investigation or not by changing his stand. So, let such report be filed by 10 days from date. Stop. List the matter under the same heading for further consideration on September 2026.
Well, report submitted, well, kept on record, my lord.
ওইখানে
Very
একটা লাইন অ্যাড করে দেবে যে ইটস নট এ রিপোর্ট, ইটস এ কমিউনিকেশন ডেটেড 22nd July 2026, filed 22nd July 2026 of officer in charge Shoshuna police station is taken on.
May I just produce the communication?
Not at this stage.
No.
Copy was given to.
No. Let the report from CBI come.
Great.
A copy of writ petition. Copy of writ petition.
Let there be an independent report.
Great. I mean, sir. Written copy, yes. Sir,
Item number 8.
May it please, my lords. My lords, I'm so sorry that I'm not there physically. I apologize, my
Yes.
lords. My lords, this matter pertains to the state police. I appear for the petitioner. The state police having frozen a further set of 4 bank accounts. My lords, can your lordships hear me, my lords?
Yes,
Can you?
yes.
Yes. So the state police having frozen a further 4 bank accounts, my lords, on 7/7/2026 of the All India Trinamool Congress. Your lordships will recollect that my lords had been seized of a similar matter where the state police had frozen some HDFC accounts. And my lords had then described that FIR as omnibus and vague. And your lordship's order appointing a special officer was upheld and sustained by the Supreme Court, saying that it was a very balanced order. Now, subsequent to that, when my lords had first indicated that your lordships would grant some interim relief on 2/6/2026, my friends at the state police promptly go and freeze a further set of accounts, my lords, on 7/7/2026. So now what is before my lords are those further sets of accounts. My friend who's in court, my lords, will just hand over a short table, my lords, of these various sets of bank accounts that have been frozen by our friends at the state police cyber cell, my lords. Agnish, if you could please hand over that short table, my lords. Yes. Your lordship sees, my lords. Now, these are all our various accounts, totaling, my lords, about 804 crores that have been frozen by my friends at the state police cyber cell. Your lordships will see 3 columns. The far left column is what my lord's order appointing a special officer for day-to-day expenditure was passed on. These are the 3 HDFC. Now, what is before my lords is the 4 accounts of Indian Bank, my lords, which is on the far right side of the table. Your lordship sees these, my lords. 4 bank accounts of Indian Bank. Letter of Indian Bank dated 16/7/2026 is how we were intimated that in fact these accounts are also frozen. Now, may I take my lords to the FIR itself? This is the same FIR for everything that is before my lords, and this is the same.
But in view of the order passed by this court on probably on 7 July, if I'm not
9 July, my lord. 9 July.
And correct
Yes.
it, 9 July 2026.
My
the
lord.
order was passed.
Yes, my lord.
Where there was no blanket order permitting the petitioner to operate the accounts.
My lord.
So the direction to appoint special officer only for the purpose of day-to-day to meet and incur day-to-day expense
Yes.
and monthly
Yes.
expenditure.
Grateful, my lord. Yes, my lord.
Beyond that,
Yes, my lord.
those accounts were not permitted to be operated.
That's right,
If,
my lord.
if that is the stand reflected from the order dated 9 July 2026,
My lord.
in that event, there is no further order need be passed with regard to freezing of other accounts.
Yes, may I just say
Because
this, my
already
lords?
this court has taken note of your concern, which was expressed on
Yes.
on 9
Day
July
to day.
2026 for the
My lord.
purpose of existence of a political party, considering
and-
their democratic
yes.
right as
And
enshrined
those,
under the Constitution of India. Now,
Yes.
beyond that, no
My lord.
further, because your other accounts are freezed by ED, as I have seen.
No, my lords. This
in
is
newspaper.
by the state police, my lords.
Yes.
These 4
Other
in
3
this
accounts,
petition.
other
The
accounts
same
where
account,
Justice Krishna Rao passed an order.
Same account
My
which your
lords,
lordship has
my lords, may
appointed.
my friend may allow me to argue,
Just-
satisfy
yes,
the
I'm just
judge.
clarifying
Yes,
the
my lords.
position,
It's
madam.
very
Just clarifying the
difficult
position.
virtually.
Please, Guruswami, just a minute. Dr.
The
Yes,
Guruswami.
same
yes.
account,
Yes.
the same account where lordship has permitted the special officer to appoint.
Yes.
Those 3 accounts were also freezed by the ED on 7th. Your lordship passed the order on 9th, but before that ED has freezed the account. So, my lord, they challenged before another court, before court number 25. There, my lord, in terms of 17A, this was freezed, which is an appealable order. So there was no interim order was passed. Against that order, they went to Supreme Court. But kindly see the order passed by the Supreme Court. Ultimately, Supreme Court uphold your lordship's order. But kindly see that.
Yes, calling it a very balanced order, my lords. My lords, the order is redact and paragraph 3, my lords, which is the operative portion. Yes.
Only, my lord, in addition.
Just a minute. Just a minute. Yes.
Now only
My
addition.
lords, now
Only
may I
addition,
just-
para 5, what I have seen, the other faction was permitted to give their
Now
objection.
the special officer can function.
Yes.
Yes. Now, my lords, may I just make
Now-
2 points?
So,
Yes.
Dr.
May I just?
Guruswamy, your
May I-
concern
Yes.
was taken note of by this court as well as by the Honorable Supreme Court, and for your day-to-day expense already orders to protect
Yes.
your right
Now,
to incur day-to-day expense and monthly expense. Orders were passed.
yes.
So
Now, may I
therefore-
just say 2 things, my lords? May I please explain my position? Why am I again before my lords? Now, I am before my lords because your lordship's orders protected us in the context of salaries and rent. This is what those expenses were covered. Salaries of our roughly over 200 employees and rent of some of the party offices, which were on rent. And those the special officer is now tasked with assessing and proceeding on it, my lords. Now, that is what that order concerns. As a political party, my lords, I also have a few other expenses. Putting up hoardings, holding rallies. These are all constitutionally and statutorily protected expenses. I am not able to function.
Dr. Guruswamy,
lords, my lord.
that will be the best situation if entire account, all the accounts are in a condition or in a state so that you can
Yes.
operate all the accounts to meet your all expenditure. But that this court has already decided that during pendency of this writ petition, court will not permit the
Yes.
petitioner to operate the account in its entirety. That's
but
why
my-
that's why court passed an order, interim
lord.
order, permitting the petitioners or petitioner political party to incur day-to-day expense / monthly expense, but not.
My lords,
monthly.
may I just say this, my lords? May I just say this? May
Dr.
I just
Guruswamy,
may I just may I
please
make 2 points?
hear this court first. If I
Yes,
pass
yes, my
a
lords, of
separate
course.
order permitting you further to operate these accounts which are subject matter of this writ petition, then
My lord.
my previous order will be faulted.
No, my lords, may I just say why that's not the case? May I just address
at
your
best,
lordships for 2 minutes?
I can give direction to exchange your affidavits. This matter will be heard along with the first.
Very
matter.
well. No, my lords, may I just
No
say 2
interim order
things?
at this stage.
I have some.
But may I just say, we'll exchange affidavits, my lord.
Dr.
My lord.
Guruswamy, I know
My lord.
you are doing these matters from the very beginning, and you know that what was the consideration of this court at the time
Yes.
of passing the first interim order on your writ petition, which
lord.
was approved by the honorable, affirmed by the honorable Supreme Court,
My
and it was observed by the honorable Supreme Court.
Complimented by the Supreme Court, my lords.
11th August
Complimented.
2026, that this is an interim order. So there's
Yes.
an interim arrangement made. So
My
if
lord.
court would have been satisfied with regard to your right to operate the bank account in its entirety, then court would have passed different order
My
on
lords.
9 July 2026.
My lords, now.
Then if I make a departure and
Yes.
make a departure and permit
Yes.
permit the petitioner political
lord.
party to operate the all other bank accounts, then my first interim order will be faulted.
My lords, then
That I will not
may I make one
Try
request,
to
my
appreciate
lords?
predicament of
Yes,
this
yes.
people.
No,
Yes.
no, and my lords, may I make 2 requests? Then only this. If your lordships allows us to exchange affidavits,
Yes.
my lords, and
Yes.
then we will come back to your lordships after those affidavits have been exchanged, because what those affidavits will show is simply this: that even their best case in their highly problematic FIR, which accuses us of organized crime, So the former chief minister, who has no charge sheets against her, is being accused of organized crime, section 1114 and 1116 of the BNSS. That is what their FIR is about. It is a ridiculous FIR, with great respect. Now, your lordships will see.
I accept your contention.
My lord,
Your
my lord.
contention that these
My lord.
FIRs there are lacunae in the FIR.
Yes,
so therefore, this
yes, my lord.
FIR independently cannot survive the test of law. If
My
that
lord,
is,
my
if
lord.
that is the situation, and accepting your contention today, if I permit petitioner
My
to
lord.
operate all the bank accounts which are subject matter in the present writ petition, in that
My
event,
lord.
what will be kept pending for final decision?
No, I bow down to that. I'm not
I
trying
have
to
something to say, my lord.
pressurize and
Kindly
take.
permit
May I
me.
just finish? May I just finish?
yes,
Yes, my lords, I'm already at a disability arguing virtually, my lords. What do I say? What do I say?
No,
I'm so
there is no
grateful.
disability.
No, no.
You are
My
very
lords,
able advocate, counsel, and
No,
you
no,
know
my
that
lords.
you can also handle the case appearing on virtually,
My
appearing
lords, my
virtually.
lords.
Yes.
My lords, may I just say this, my lords, just twofold. My lords, my friends, even the enforcement directorates, the fact is these accounts are frozen by the state police. Now, their best case of their own ridiculous FIR is this, my lords, that there is an accusation pertaining to 160 crores. They have frozen 800 crores worth of bank accounts. Your lordship knows this, my lords. That's the first point. But the second point is this, my lords, and this is an important point. As a political party, my lords, political parties have threefold basic expenses. One is rental, two is employee salaries, and three, my lords, is to function politically. We want to hold rallies, we want to put up hoardings because there are pressing issues to be agitated. We are the principal opposition party in the state.
But let it be
We are
decided
not able
first
to.
that in whose favor this account will go ultimately, subject to the decision to be taken by the ECI.
My lords,
That was considered by this court in the order dated 9 July.
Yes, my lords, and
Because
orders
there
have
you
been
know very
passed.
well, Dr. Guruswamy, that
My lord.
there are two factions. And there is infighting between the factions. Both are claiming to be the original political party, and the issue is the ECI is insisting of that issue. So at this stage, beyond bare necessities, bare financial necessities, court will not permit anything.
So very well, then your lordships will allow us to exchange pleadings, my lords.
Today, if I pass
My
this
lord.
order, Dr. Guruswamy, then
My
you will
lord.
find it very difficult to advance your argument before the apex court when my order will be questioned.
My lords, may I just say this? Right now, my lords, Bengal is operating without an opposition. That is what has happened.
Yes.
That is what has happened.
Yes, that was the reason.
Yes, yes.
Accepting submission of Dr. Singhvi, this
Yes.
court passed this order
Yes.
so that
Yes.
that a petitioner political party can survive during the
And my
pendency of
lords,
the petition.
may
If
I?
the political party
Yes.
withers away, nothing remains. What will
Yes,
be
nothing
decided
remains.
for whom this court
And
will decide?
and
The
your
writ petition.
lordships will also
Relating
be
to freezing of
interested.
bank accounts.
No, my lords, and your lordships will also be interested to know that the so-called rebel faction is not, in fact, meeting the election commission, is not exercising, and that their own lawyer, who had appeared before my lords when Dr. Singhvi was addressing your lords, accepts that they should go to the election commission. They are not doing that. Just like the other rebel faction, Lok Sabha is not going to the speaker. So this is what is also happening, my lords, and therefore, this political opposition in the state is hemmed in. But I'll just say this, my lords. We are very content, my lords, to be before your lordships. We will exchange pleadings. I am acutely aware that I am, in fact, at the Calcutta High Court, my lords. This was the original Supreme Court of India. Your lordship knows the history, my lords, of this country. So we will come before my lords. When pleadings are exchanged, I will come physically. We will argue the case out. I will demonstrate the ridiculousness of the FIR.
No, what is passing through my mind that there is no scope for passing interim order in view of the order passed by this court on 9 July 2026 on a writ petition being WPA 14081 of 2026.
Of 2026.
So,
we will seek final adjudication from my
and
lords.
this writ petition will be heard along with WPA 14081 of 2026.
Very well, very well. I'll be grateful, my lords. We'll argue this out. I'll
And if
show
you
my
persuade
lords.
this court to pass further order permitting All India Trinamool Congress to incur further expenses, then my
Yes, my
first
lords.
interim order will be faulted.
No, my lords, what I will seek to
Because
do.
you are
I will-
aware of the consideration of this court while passing that interim order.
Yes, my lords. My lords, but what I will seek to
something
do
to say, Minister.
is to protect your lordship's original interim order
Yes.
and to demonstrate when the pleadings are complete
Because very
of
purpose
the
very-
nature of
Yes,
the illegality of the FIR.
very purpose of that interim order would be defeated in that.
Yes, but my lords, also we would like to argue out the FIR, which in law is not just omnibus, my lords, as your lordships have correctly said, and the Supreme Court agrees with that. It is illegal. You cannot have an organized crime challenge or charge without at least 2 FIRs being registered against that person. Then it becomes organized crime. And my lords, the Enforcement Directorate and the Civil Police are in fact discharging their functions in this way. You
But
take an
prior to-
opposition leader.
Prior to that, you have to protect the interest of your client before the ECI.
Yes, my lords,
Otherwise,
that of
everything will
course.
go.
My lords, I am a day-to-day practitioner before your lordships. I will come and satisfy my lords and
Very
protect
good.
my lords' interim order.
I
I'm
have
so
something to
grateful.
say.
Yes.
Lord,
yes,
I have
Mr.
something to
Majumdar.
say.
Yes, Mr.
Lord,
Majumdar.
when your lordship has passed the order on 9th, because your lordship has taken, the FIR was started on 17th and the bank freezed it on 18th.
Within a
Now-
very short
Within a 1 day, it was freezed regarding
And
those
that
3
was
bank
one of
accounts.
the reasons for
Yes,
interfering with
Yes.
your lordship is correct. Now,
Yes,
this
my lord.
bank account, my lord, was freezed on 7th of July 2026. And your lordship will be shocked to know just one report. Kindly see the report. Huge amount of cash. Just kindly turn to the second para.
Second page.
Whether your lordship on merits also will permit it, because their allegation, these are illegal proceed of crime. But kindly see para 2.
First page, paragraph 2.
No, second page. Second page. Kindly see from 2018, the cash deposit, amount of cash deposit.
Wait.
The chart.
Yes. There is a tabular form. in the-
Yes, 2018, where cash deposited by so and so. Now kindly turn to the next page. 7 crore. Now the second one, Debraj Chakraborty, your lordship got it. Lord, his anticipatory bail because of the extortion case, the other bench has rejected his prayer for bail. He has deposited 10 crore rupees. Now other, my lord, 20 crore rupees, almost 10 crore rupees.
Baguyati case.
Yes. Now another, my lord, the cash deposit from this period, your lordship will find total another 10 crore. My lord, got it. It is, my lord, on the merits I'm saying so. And not only that, the money
My lord,
has
sure.
been transferred.
We will argue, my
Just
lords,
1
on
minute,
merits
madam,
then.
just 1 minute.
Fine.
I did
Let
not
us argue
interfere.
on merits. If you
Yes,
are
yes,
going to,
just 1 minute.
Let him
if-
place his case. Yes.
Now, your lordship will found from this account, which they are now claiming to defreeze, from this account, 30 crore rupees has been transferred to Lips and Bounds, which is a charge-sheeted company SSC scam. And 8 properties of my lord Lips and Bounds has been freezed by the ED.
yes, and you've secured your 160
Yes.
crores.
Now,
You've
this
secured
is
your
the
160
situation.
crores.
Now,
Let's go over the FIR then, my lords.
So
My
senior
lords-
is there. If
Yes,
required,
my lord-
Mr. Basu, you are Mr. Basu. Mr. Basu, I will hear your senior. You need not be worried.
one Sumit
My
Roy,
lords,
during
they
this period,
have
2000
secured their 160 crores.
He is
May
not
I then
allowing me
take
to
your
say
lordship?
I did
My
not
lords,
inter.
they have secured.
I did not interfere.
Please be quiet. I will hear you. Please.
I-
Yes,
Today
yes,
I'm not
yes,
going to
yes.
pass any final
But
order.
so far as these bank accounts are concerned, one Mr. Sumit Roy during period 2018 to 2021 deposited almost 7 crore rupees.
My lords,
Debraj
where are these
Chakraborty, he has
allegations coming
deposited
from, my lords?
from this
Where are these
period-
allegations coming
So
from?
that's
What
why
is the
Mr.
paperwork?
Majumdar,
Yes,
that's why
where are
Mr.
these
Majumdar,
allegations
I am
coming
not
from?
interfering with at this stage. So far, the prayer for prayer couched in this petition
Yes.
for interim relief.
Blood kind.
And
Yes.
whatever you are saying, put it on affidavit.
Yes,
Yes,
They
put
will-
it on
they will-
all
affidavit.
bank
Don't just
vouchers are
argue in the
there, all
air.
bank vouchers.
Yes, yes,
They
don't
will
argue
give
in the
reply
air and defame
and the
people.
matter to be heard. Because
Yes.
today, nothing in view of my order dated 9 July 2026 and
Lordship.
subsequent order passed by the Honorable Supreme Court on 11th August 2026.
Yes.
No further order need be passed on this report.
Lordship.
Very well. We'll exchange
for your lordship's
affidavits, my lords.
consideration,
My
all
lords,
the
this is
vouchers.
not,
It is
my
not
lords,
a-
all these vouchers, these are arguments on merits. Then my friends may just allow us to argue on merits, my lord.
Later
Where are
argue
these
on merits,
allegations?
later argue on
Where are
merits.
these
I
allegations
have no
coming
problem.
from?
Yeah.
He has,
Later
he has
argue on merits.
filed,
Court is
he
not
has
very
filed
clear.
nothing
You
in
have to
paper.
fight Dr. Guru
He has
to
filed
advance
nothing.
Whatever,
Yeah.
blood, whatever I am submitting
Yeah,
before
my
your
lords, he
lordship
has
from
not
the record
filed
I am
anything in response and making
Today we are at the
allegations.
motion stage.
Yes.
So therefore,
Yes.
court is contemplating to pass an interim order
Lordship.
if there is a case and if situation demands.
Yes.
But
Yes.
it appears from the it appears considering my previous order dated 9 July, no further order is required.
Deeply obliged.
Your Lordship, can I?
No, my lords, if he is going to make allegations like this and he knows it's
What
transmitted
allegation?
all
We
over,
have
then
the
he should
vouchers. He's saying-
then
he's
he
saying
should
allegations.
share this with me. Have you shared the vouchers with me?
He's saying allegation.
You've been
We
served.
have the voucher.
You've
from
been
the-
served. Yeah, I'm arguing of the
I
FIR.
am asking both of you that a chart is given placed on behalf of petitioner.
Yes.
Now in this chart there are three
Yes,
accounts
my lords.
in connection with which I have passed an interim order.
Yes, my lord.
On
Yes.
9th July.
Left hand side.
My lord.
These three
My
accounts.
lord.
Extreme left hand side
Yes.
column.
Yes, my
Extreme
lord.
left column. Now,
My
so for
lord.
the extreme right side column, there are four accounts
Yes.
Yes.
which have been which are debit frozen and
By
these
the
are
state
subject
police.
matter of the present petition.
Yes.
My lord. My lord.
And what are those accounts which are freezed by ED? Wherein Justice
My
Ram
lords,
has
this
passed
has
an
not
order.
been frozen, but now,
Yes,
my
the
lords, they
same
will go
account
and
as
freeze it
NTF.
right now because this is what they
Same
do.
account on which your lordship has passed the
This is
interim
not frozen. This is not frozen by ED. The ones in this repetition before your lordships.
So the accounts.
So I don't know what he's talking about, my lords.
My query is in connection with these three accounts. ED took steps.
Yes.
Yes,
And
only
that
on
was-
those
and
HDFC.
in that writ petition, no interim order was passed,
And
permitting the petitioner to operate those accounts.
it was your lordship.
But
No,
now
no,
the
my
special
lords.
officer- yes,
My lords, you see, my lords, the
that
three
clarification I
HDFC.
required from both of you.
Yes, yeah, he is wrong, my lords. You see the three HDFC accounts, far left
Yes.
corner of that one pager. Those three accounts, subsequent to your lordship's interim remarks, 2/6/2026, when my lord said this is omnibus, this is clearly problematic, then they promptly go and freeze it, my lords. The ED freezes only these three.
Therefore, these three accounts are subject
Yes.
to the writ petition. So
No,
which was
they
heard by
are
this court, which was
yes,
heard by
yes,
this court,
yes.
and an interim order was passed on 9 July, and these three
Yes.
accounts are also subject matter of the writ petition challenging action taken by ED.
Yes.
Yes, my lord, that went to the Supreme Court. Now, today,
now-
what
now
is before
today-
my lords is
today
not
what is the-
frozen.
Today, what is the situation? Because this
Yeah.
court passed an interim order. Interim
Yes.
order permitting the petitioner to incur day-to-day expenditure and monthly expenditure
That was upheld, my lords.
through special officer. Through
Yes.
special officer. But coordinate bench did not interfere with the steps taken by the ED, thereby freezing those three accounts. Now, ultimately, both the writ petitions, the orders passed by this court and the order passed by the coordinate bench, appeals were, SLPs were preferred.
Lordship.
And the
My
order
lord.
was passed by the Honorable Supreme Court on 11th August 2026.
Yes, my lords. Yes.
Whether by virtue of this order passed by the Honorable Supreme Court on 11th August 2026, petitioner's organization will be permitted to operate account.
Yes.
Yes,
Can
that-
you see
that's a fair point, my
Both the
lords.
writ petitions were considered there.
Because
Yes, yes,
their writ
yes,
petition
both
before
were
the Supreme
petitions.
Court were
Were
dismissed.
considered.
So far as their writ petition was
No, no,
concerned,
nothing.
only one line was added that they can put their objection
To the special officer.
to the special officer.
My lords,
And
we will
These two SLPs were filed by the dissident group organization.
One by them challenging the order passed by the Justice Krishna Rao, and your lordship's order challenged by them. Yes. Both the matter.
So there
went
are
to the
cross
Supreme Court.
SLPs.
Cross SLPs.
there are cross
and both were
SLPs,
Yes.
but
One
what is
by the
before?
dissident group against the interim order passed by this court, and
Yes.
another by All India Trinamool Congress. One faction of All India Trinamool Congress questioning the order of Justice Krishna Rao.
Lordship.
My
Now,
lords, and what the Supreme
Both
Court
the
upheld.
SLPs were disposed of via order dated 11th
Yes.
August 2026.
Yes, and what
According to the
what?
order passed by this court.
Yes.
Yes,
9
yes.
July.
Yes.
As a
Yes,
result,
my
the
lords.
petitioners organization, that is All India Trinamool Congress, will be permitted to operate the
Yes.
bench
Yes,
special officer.
yes, my lord.
Yes.
So that
Yes,
is the
my
situation.
lords.
Yes.
That is the situation.
So therefore, your interest is addressed by this court as well as considered by the Honorable Supreme Court.
Yes, my lords, and we will demonstrate through the cross pleadings that we will exchange with my friends. We will demonstrate that we are not able to function only with salaries and rent being allowed. As a political party, my lords knows this. We are a vibrant democracy, my lords. We need to have hold meetings. We need to have
And what
holdings.
is-
We'll
just a
demonstrate
minute,
all that.
Just a minute. What is
Yes.
the fate of the SLP preferred by All India Trinamool Congress against the order passed by the coordinate bench regarding ED's action?
That is the same was there on single order it was passed. Yes. It was disposed of.
It's all a single order, my lords. It's a single
Yeah,
order
Para
which
four.
your
Can you see
lordship
Para
read
four
and
is
your
taking care of
lordship
everything.
Your lordship saw
We
paras
are
3 and
also
4 of
conscious-
Justice Sundaresh's order.
we are all conscious of the fact the main writ applications is pending consideration WPA number so and so and so and so before the High Court. Thus, any decision on the merits will have a bearing effect of this pending writ petition. As the interim order passed by the High Court takes care of the interest of the parties, we are not inclined to interfere with the interim order passed by the.
So
This
therefore,
is-
the arrangement which was effected by the interim order dated 10th August, 10th, 9
9,
July
my lord.
2026,
9 July.
it
Yes.
now it can be effected.
Now it can be
Yes.
effected, and only my submission, but after going through this is only in connection with the state which has freezed the account. Because your
My
lordship
lords,
will
that
find
is not,
we are
my
not
lords,
in
that is not before your
Kindly see the-
lordships.
kindly
My
see the
friends
order.
are now,
We are
he's
not-
going to
Perhaps-
argue
perhaps-
vouchers again, my lords.
Perhaps you
That is
cannot
not
submit
before your lords.
This
Yes.
submit this in view of the order passed by the Honorable Supreme Court.
Yes.
Yes,
Now
my
see the
lords.
last-
Now,
last line-
the
last line,
the
your lordship
date
can
of the date of the order passed by the
That
Supreme
I've
Court
seen,
is
yes.
11/8. 11/8. That is subsequent to all three
There
things.
is one addition, that is paragraph 5.
Yes.
Yes.
So for my order is concerned, interim order which was passed on 9 July.
Now your
Yes.
lordship will
That
kindly
is
see
the only change which was
para 4,
Yes.
4, last 4 lines, kindly see.
My lords,
As the
I
interim
don't
order
believe that
passed
this
by
is
the High
before your
Court in-
lordship today, my
No,
lords.
that
He
is
should
not
have
before
argued
me.
this.
No, that
Yes,
is
he
not.
should have argued this
You are
before the
absolutely
Supreme
correct,
Court,
Dr.
my
Gupta
lords.
ji, that is not before me.
Yes, yes,
This is-
he
I
should have
want-
argued this.
I want clarification from the respective councils, all are the
Yes.
competent councils before me, that what is the present situation in view
My
of
lords-
the order passed by the Honorable Supreme Court on 11th of August.
Yes, my
Now it
lords, your
appears
lord.
to this court also that you have to permit the special officer to function.
Yes, my lords.
Yes.
Because
No doubt about
the
it.
order
But there
of the
is no
Supreme
doubt.
Court is subsequent to
my
everything.
second query is this four bank accounts.
Indian Bank.
These
Yes.
bank accounts are debit frozen in connection with one singular criminal prosecution.
Yes.
Where
Yes.
is the particulars of the
Yes.
transaction?
You are kindly see.
Can I please draw your
The
attention to
FIR
page
is
71
P2,
of
my
our
lords.
petition? Page 71 is the complaint, and clearly in paragraph number 2,
Again, they are going into the
Then
complaint.
let us
Let
talk
it
about-
let it be argued on merits.
Sorry,
my lord. Let it. We are ready, my lord.
Where is the FIR?
your lordship.
74.
FIR is page 67, my lords, annexure P2.
Just-
P2, FIR. May I just take your lordships through the FIR? Your lordships, my lords
this is
has
the
annexure
singular
P2.
FIR.
Singular effect.
Yes,
Singular.
yes. Now please see, my lords, please see the offences that they're alleging.
Dr. Guruswamy, this
My lord.
FIR at page 67 includes all the four bank accounts.
Everything.
Which are
This-
being maintained with Indian Bank.
No, your
Yes,
lordship.
my
With
lords.
respect,
The-
your lordship, I just request you to just have a look at page 71 of the complaint. And this is the reason why ED has not interfered with Indian Bank also. If you come to page 71, you will see the
Yes,
complaint
it's the three
talks about
HDFC accounts.
only
Three
HDFC account.
HDF.
The
Page
complainant
71.
Vishwanath Das has only complained about transactions which he feels is illicit transactions through HDFC account. And that is the reason why also the ED investigation only relates to these HDFC accounts. And
So according to this complaint also centers around those HDFC.
The
bank.
HDFC
Exactly,
accounts.
and
Yes, my
therefore
lords, the three
your-
HDFC accounts.
your previous
And what is now,
Both the councils have perhaps have understood the situation in view of my order 9 July. No further order is required to be
Yes.
passed at this stage.
my lords, we'll
You argue
exchange
your
pleadings,
case.
my lords.
You
Yes,
argue your
yes.
case at the time of
Yes.
final.
Very well, very well. Very well. We'll
My
do
report may be
that.
kept with the record.
Yes.
My report may be kept with the record.
can we get a copy of the
Eh,
report?
No, it's an investigation
My lords,
stage. We
he
cannot give
has,
it to them.
he has made all these
cannot.
allegations. We should know, my lords, what he is alleging.
No, we, at
The
this,
sources-
but this is the
the
part of the
source
case study.
money-
At this stage, we cannot give it.
And-
to
So
them.
you
So-
will get it through their affidavit within
Yes.
certain
Yes,
time.
my lords. Yes, my lords. They may file it.
Yes.
They may file all of this in the affidavit. These
Whether my
frivolous
order passed on
allegations are
9
made,
July
my
is
lords.
part of the writ petition.
Yes,
Yes,
and
yes.
your
Page
lordship may,
74.
your lords,
Page 74.
Page 74.
Yes.
Page 74, P4.
And just it is my duty to point out to your lordship, kindly see para 4. Your lordship will find their submission was apart from these three bank account.
Matter is heard in presence of the matter is heard or the writ petition. Writ petition is heard when Dr. Guruswamy, Dr.
Thank you, ma'am.
Menka Guruswamy,
My lord.
learned senior advocate represents petitioners and Mr. Rajdeep Mojumdar, learned additional advocate general represents state response. Stop. By presenting this writ petition, comma, inter alia, comma, challenge is thrown to the criminal prosecution which has been initiated by the concerned police authority based on FIR being Bidhannagar Cybercrime Police Station. It's a Bidhannagar Cybercrime Police Station. Bidhannagar Cybercrime Police Station. Case number 94 of 2026 dated 18 June 2026. Stop. It is submitted on behalf of petitioner that after initiating aforesaid criminal prosecution, three bank accounts of three accounts of All India Trinamool Congress, namely 500-124-6648, comma
4 accounts, my lord.
699105630 504677 and 207904548399, which are maintained with Indian Bank. Which branch?
Para 20, my lord, they have stated. Para 19, page 20. Sorry, my lord, I'm sorry. Para 19, page 20.
Now, whether the branch is stated there?
Branches, they have not
Harish
stated.
Mukherjee Road. Harish Mukherjee Road branch.
Harish Mukherjee Road, 32A, Kalighat Road, my lords. Harish Mukherjee, page 87. Page 87, the letter from Indian Bank. It's Harish Mukherjee Road branch, 32A, Kalighat Road. 4 accounts, my lords. 4 bank accounts. Your lordship has page 87, annexure P6.
Are debit frozen. Stop. Prayer is made for permitting the petitioner. Prayer is made for permitting petitioner political party to operate aforesaid 4 bank accounts since there are certain lacunae in the criminal prosecutions initiated based on complaint dated
18th of June 2026.
Page 71.
The FIR, my lords.
Yes. Complaint
Yeah,
dated,
FIR is 67, my lords.
complaint
Page
dated
67.
18 June 2026.
Yes, my lords. 18 June 2026.
Next paragraph, it is submitted on behalf of state respondents. It is submitted on behalf of state respondents that steps have been taken in connection with aforesaid criminal prosecution in accordance with law, and prayer is made thereby permitting the concerned police authority to conduct investigation. Stop. Next paragraph. This court had occasion to deal with similar situation in the writ petition while passing interim order on a writ petition being WPA 14081 of 2026 within bracket All India Trinamool Congress and another versus the state of West Bengal and others. Stop. Vide interim order dated 9 July 2026. Court permitted petitioner therein, petitioner political party therein, to operate bank accounts through court appointed special officer for incurring day-to-day / monthly expenses. Stop. learned advocates representing parties has placed before this court order of the Honorable Supreme Court dated
11/8, my lords.
11th
11/8,
August
20.
2026, passed on two special leave petitions within bracket criminal being 13322/2026 arising out of order dated 20 July 2026 and special leave petition criminal number 14691 of 2026. Stop. On perusal of the order passed by the Honorable Supreme Court on 11th August 2026, it appears that order passed by this court, interim order passed by this court on 9 July 2026 on the writ petition being WPA 14081 of 2026 was not interfered with. Stop. Next paragraph. In view of the order passed by this court on 9 July 2026 and subsequent order passed by the Honorable Supreme Court on 11th August 2026, no further order need be passed at this stage, thereby permitting the petitioner political party to operate. No further order need be passed at this stage on this writ petition as an for effecting interim measures.
But kindly mention
Effecting interim measures.
But kindly
For
mention
effecting further interim measures.
But kindly mention the Indian bank account number also.
Stop. That I have already mentioned.
No, here, my lord,
Mention
kindly
it.
mention.
Next paragraph. Let this writ petition be heard along with the writ petition being WPA 14081 of 2026 analogously. Stop.
Very well.
Respondents are directed to file affidavit in opposition to this writ petition by 4 weeks.
Make it
Very
6.
well, my lords.
No.
As
By
you
4 weeks
4 weeks.
from date and affidavit in reply thereto, if any, whether we are
Yes.
getting 6 weeks prior to vacation. Yes.
My lord, yes.
My lords,
We
yes,
have.
you are, my lords. You're getting. My lords, also, if my
Till
friend
10th,
could put
my lord,
on
we are operating.
affidavit
Please,
these
please,
allegations that he's relying on, my lords. He must place it on affidavit, my lords, because we must know
We are
what is
oper-
this case against
Yes.
us.
Just 6
Yes.
weeks. On 9th, no, on 8th.
That will be better, my lord.
Yes, yes.
My lords, if your lordships could grant us, please, 4 weeks, my lords, because it
The court
starts
will not
getting
be able
into
to
the
hear out these
October
hearing
holidays.
matters before vacation.
Yes, my
Not
lords.
possible. Not possible.
Very well. তাহলে করো।
My lords, if he has all the allegations on hand, my lords, I'm not sure why he's so reluctant to file within 4 weeks in any case.
He
So
has
it
to
gives us
oppose in
some
each and
time.
every submission.
we-
He doesn't
you
know
know-
what similarity our practice.
No,
in
no, what
our High Court.
I know, my
That
lords.
will allow this court to complete
Yes. Yes.
complete dictation.
Yes.
Complete dictation.
Please, my lords.
Yes. By 5 weeks from date, and affidavit in reply to be filed by 2 weeks after puja vacation. 2 weeks after annual vacation. Stop. Next paragraph. Parties shall be at liberty to mention this matter for hearing after the time fixed herein above for exchanging affidavits.
Very well.
Analogously to Corona. Because it will come on a particular day.
Yes, yes.
I think you
Yes.
Your lordship, can a date be fixed? Can a date be fixed?
আরে ভ্যাকেশনের পরে কোন কোর্ট থাকবে?
You know the docket
it is-
position of this court.
My lords, if your
Out
lordship
of
could
which
just
30% matters are yours matters. Are your
my lords,
matters. Yes.
My lords, if your lordship could just mention one line, my lords, that my friends may paste their allegations as part of that affidavit. So we know. So we know.
Sentence change karo. There is no scope for passing any. There is no scope for passing any interim order at this stage, and writ petition needs to be heard on exchange of affidavits.
Yes, and that my friends may place the allegations on affidavit, my lord. So we know what we are responding to.
Yes, will say.
Yes, because he keeps saying, otherwise he keeps saying voucher this, voucher that. I don't have access to his iPad, my lords, to know what vouchers he's relying on.
By report filed on behalf of Cybercrime Police Station, Vidhannagar
Yes.
Police Commissionerate, dated 27th August 2026, by Mr.
Grateful.
Majumdar, Learned Additional Advocate General, is taken on.
Grateful.
Let it be on a sealed cover. Can you keep it in lordship's record?
My lords, if this is a report of the state police, my lords, why should it be in seal cover?
As your
Will
lordship.
be filing affidavit, and these points will be reiterated
Yes.
herein.
These are on the
Yes.
spot.
Yes, my lords, if that report could be added to his affidavit,
But
my
you have to
lords.
place this before your lordship.
Yes.
But-
My
Now,
lords,
now
that-
you can make submission. My order is over. Dictating so far dictation of my order is over.
My lords, then we will only submit this, that your lordships, when Saturday and Sunday comes, has a very pleasant weekend, my lords. That is all we submit.
Now
And
the
happy
special
Raksha
officer is
Bandhan, my
functioning.
lords.
Special officer is functioning.
But I have what I have been told, both the fraction, they have given their letters before the special officer. But they have put their claim and they have given their objection.
Very well.
But the special
For the next
officer
matter.
Grateful, my
Item number
lords.
9.
I'm praying for not this, my lord. For not this.
Why?
The advocate is went well for his treatment. Conducting advocate is went to Vellore for his treatment.
For treatment.
I'm judge.
Previously matter was taken up.
No, it is first time.
Who is the conducting advocate? Let me see.
Mohammed Shamim.
আগে থেকে বলে দিলে আমরা এতক্ষণ থাকতাম না।
They are praying for registration of FIR.
FIR has already been registered, my lord.
FIR has already been registered.
Yes.
Very well on personal ground.
I am not opposing.
At the time of call, accommodation is paid for on behalf of petitioner, since learned advocate is unwell. However, state respondents are represented by learned advocates. Acceding to the prayer made on behalf of petitioner, hearing of this matter stands adjourned. When your the learned advocate will return?
First week of September.
September. According to the prayer made on behalf of the petitioner, writ petition is hearing of this petition is adjourned. List the matter under the same heading for further consideration on 15th September 2026. Next, it is made clear that no further adjournment shall be granted on the next date.
Much of this.
Item number 10.
Your lordship, I'm appearing for the petitioner in item number 10.
Madhu Puja is also.
And I'm for the private respondent numbers 5 and 7.
The petitioner's elderly mother, she is the absolute owner of a land measuring 56 decimal wide, deed number 7761119840425595. All of this deeds has been annexed in page number 12. Your lordship, the petitioner's mother, who is Ambalika Pal, she has been the owner of.
You are praying for
We put this in action because the private respondent number 5, 6, and 7, they have. Your lordship, the FIR is in page number 39.
complaint.
The private respondent number 5, 6, and 7, they have illegally encroached the land.
Any private respondent?
My lord, I'm for the private respondent numbers 5 and 7.
Now, this is an agricultural land.
Yes,
So you are
For
praying,
50 to 45 years, two farmers, Mr.
you
Bimot
are prevented from cultivating the land.
Mhm.
You are prevented from cultivating the land.
And now private respondent number 5, 6 and 7, they have encroached the land, they have erected cemented pillars and they have also done fencing around that state land. And when the
So
petition,
they have started construction.
yeah, they have started construction. And petitioner, the son of this elderly woman,
My lord, I beg to appeal for the
has-
state, your lordship.
he has also filed for a complaint on 14/7/2026. However,
Yes,
no
what
effect.
is your stand?
Lord, I'm denying the allegations. I'm denying the allegations, my lord.
So why you are constructing on agricultural
And
land?
as far as my instructions are concerned, my lord, we are not making any construction on the land.
You are not making any suit.
As that is the instructions which I've
Any,
received from,
any suit is pending or any proceeding before the tribunal.
not to my instructions, my lord. No suit is pending.
Where is your complaint?
Page number 39, your lordship.
My lord, I beg to appeal for the state in this matter.
এটাকে করো মিউট করো any communication from the police?
I led by Mr. Matha.
Now it is submitted that no, yes, who is appearing for the state? Yes, yes. What is your submission? Tell me. Me unmute karo. Yes, yes. What is your submission? Yeah, I cannot hear you. You are not audible. Yes, yes.
I'm sorry. Can you lordship share me, Maharaj?
Yes, yes.
Kindly just take a look at the prayers of the writ. Maharaj, my submission is the writ petition is not maintainable.
If your lordship kindly takes a look at the prayers, Malaj, the prayers essentially seek for a mandamus for restoration of possession, Malaj. Kindly see the prayer in the writ petition. The writ petition in its form is not maintainable. And Malaj, I also have instructions that a 144 proceeding, Malaj,
Yes,
corresponding one.
that is reflected from the report submitted on behalf of police authority. Yes, you are correct. From
in June, they file a 144, and today, Malaj, that 144 is not reflected in the writ petition or its pleadings anywhere. Now they are seeking a mandamus.
affidavit of service filed on behalf of petitioner is taken on record. Petitioner prays for direction upon the concerned police authorities, which will protect right of the petitioner over agricultural land in question. Stop. It is alleged that private respondents have started have raised fencing, have raised fencing, and started to construct pillars. Stop. Next paragraph. Learned advocate representing private respondents has opposed this writ petition, and it is submitted that no construction was made on the agricultural land in question by private respondents. Next paragraph. Learned advocate representing state respondents on virtual mode. No, learned advocate representing state respondents appears on virtual mode. Stop. A communication dated 12th August 2026 of officer in charge Memory Police Station is filed today and same is taken on record. Next, copy of the communication be made over to the learned advocate representing petitioner. Next paragraph, it is disclosed in communication that a non-cognizable report was submitted dated 4th August 2026 on making preliminary inquiry. And it is also disclosed that police authorities are keeping vigil so that no untoward incident takes place. Next paragraph. In view of respective submissions made on behalf of parties, it is found that by presenting this writ petition, petitioner prays for direction upon the concerned police authorities to evict private respondents from the agricultural land in question. Stop. If petitioner finds that his right over the agricultural land is infringed by private respondents, in that event petitioner needs to approach civil court, needs to approach appropriate forum / authority in pursuit of remedy. Police authority is not the appropriate authority to decide right of the petitioner over the land in question. Next paragraph. However, concerned police authorities are directed to maintain peace and tranquility at the local so that no untoward incident takes place. Writ petition stands disposed of. Next.
Item number 11. Lordship, I beg to appeal for the petitioner.
I am calling for the respondent number 4, madam. Private respondent number 4.
Lordship, this is the affidavit of service.
Yes.
There are, your Lordship, two, excuse me.
What you are praying for?
Lordship, there are two sets of prayers. First is that the petitioner has been served with a notice under section 179 of the BNSS, in the form of a witness, because he has knowledge regarding the facts of the matter. But those two notices, when it was served, the dates were already over. Means the notices were served on 26th of July, and the date on which he was supposed to come was 24th of July. He had served 2 emails before the concerned police officer to serve another notice, but those were not served. Instead, the police had called him over phone, and on 31st of July.
This is one prayer. The second prayer is that when the petitioner downloaded the FIR, the complaint from the website, it was showing that the section is 336 within bracket 2, which is a non-cognizable offense as well as a bailable offense. But the petitioner cannot seek bail because he has been asked to come as a witness, and he's not a FIR named accused. So over here, FIR is also not maintainable because that's a non-cognizable offense.
But you are not the FIR named person.
Your Lordship.
Why you have no locus standi to challenge the FIR?
Your Lordship, but
Why you are taking this point?
Lordship, there are 2 points. The first is that so that a further notice be
If you would have been FIR named person, then question would have been different.
The FIR named person is also made a party, Your Lordship.
This is not his writ petition. Not to proceed further in the investigation of Newmarket police station. How you can maintain this pair? You are not an FIR.
Lordship, I'm apprehending arrest as well because
Yes?
I'm apprehending arrest as well because as I have not complied with these 2 notices, there is every chance that when a third notice is also not
move an anticipatory bail.
Lordship, as well
Move an pre-arrest bail application.
But over there also, as I'm not an FIR named accused also, Lordship, it is also not maintained. There are 2 sets of prayers. As well as to serve me another notice, I will comply with them.
Any instruction that petitioner received it after the date was
According to my instruction, my lord, yes, this is the report. This is our second page of the report. Now he's taking the plea. He's aware, very much aware.
On 26 July.
Complied with the notice now. Yes.
তুমি বলো ম্যাজিস্ট্রেট ছাড়া পারমিশন ছাড়া করতে পারে না ইনভেস্টিগেশন করতে পারে না বলো
That is not permissible.
No.
নন কগনিজেবল অফেন্স আছে
ওটা বলেছি এবার ওটা আমি
Today, if court permits the petitioner to appear before the police authority,
no
then,
court.
what would be the stand of the police authority? Obtain instruction. Yes. Matter is heard in presence of the learned advocates representing the petition. Stop. Having heard the learned advocate representing the petitioner, it appears that petitioner could not appear. Petitioner did not appear in terms of the notice issued by the police authorities in connection with Newmarket Police Station case number 5 of Newmarket Police Station case number 5 dated 15 January 2026. Stop. It is also submitted that petitioner apprehending coercive steps due to failure on his part to comply with notices issued by the investigating authority. Next paragraph. Learned advocate representing the petitioner is directed to obtain instruction that if petitioner appears before the investigating officer on a date to be fixed by this court, whether investigation which has been initiated will be affected or not. Has been initiated, whether investigation which has been initiated in connection with aforesaid criminal prosecution will be affected or not. Let stop. Let a further report be filed on the next date. List the matter under the same heading for further consideration on. On 3rd September 2026.
Directed that the learned advocate for the petition. Perhaps it will be learned.
Yes, দেখি একবার কি বললাম লাস্ট সেন্টেন্সটা বলো তো যেখানে ওখানটা বললাম কি হতে পারে হ্যাঁ ওই জায়গাটা
রিপোর্ট দেবে তারপর তো যাওয়ার কথা
না
নাম্বার
আরেকটা লাইন অ্যাড করে দেবো
রিপোর্ট দেবে
তারপরে যাওয়ার কথা
he has to take instruction আরেকটা লাইন অ্যাড করো communication dated 24th August 26 of 24th August 2026 of officer in charge Newmarket Police Station Kolkata is filed today and same is taken.
Lordship, till that date no coercive steps
no
it's a bailable offense.
কেউ কোনো নোটিশই দিতে পারে না তুমি
2 p.m. fixed matter, item number 206.
Wait, please, Manoj. By this petition, my lords, I'm challenging the issuance of the non-bailable warrants and the proclamation proceedings, my lords, that have been initiated against the petitioners. Now, as you, my lords, may I only mention that the FIR is registered on 30th of July 2026.
In that matter.
In that matter, it's the same matter.
Where you appeared on.
Yes, my lords, I bow down. On the same day itself, my lords, non-bailable warrants have been issued. Same day. FIR registered, application is made by the IO for the issuance of non-bailable warrants on the very day, my lords. And within 10 days of that non-bailable warrants, my lords, that is on 10th August 2026, proclamation proceedings have been started. Now, if your lordship sees the order which issues non-bailable warrants, my lords, it relies upon a Supreme Court decision in Dawood's case, my lords, which says that at the stage of investigation also, non-bailable warrants can be issued. Your lordships may have, my lords.
Page 152.
152. My lords, is the order. 152 is the remand order.
Remand order.
Remand order. 153 is the order. Now, please see this order, my lords, and whether it complies with what the Honorable Supreme Court and your lordship's court has laid down as far as issuance of non-bailable warrants are concerned. So, on the same day, the IO has submitted two separate prayers after passing of order of remand. IO has prayed for safe custody of seized money and gold at the treasury, considering the huge volume of cash. Her peruse considered, it is submitted IO that the cash, etc., we are not considered. My lords, the next paragraph after that, the IO has also prayed for the issuance of non-bailable warrants against the accused Najimuddin Mandal on the ground of conducting raids at the outside of the state and extraction, etc. Heard, peruse, considered. Accused is named in the FIR and there are mention of other criminal cases against the accused in the FIR and there are materials against him in the case diary. Case diary reflects that steps have been taken to apprehend him, but it prima facie appears that he is evading the same. Section 75 of BNSS corresponding to 73 of CRPC applies to the case in hand, considering the material in the CD and submission of the IO in the decision of state versus Dawood Ibrahim and having provided has provided that the magistrate has power to issue warrants under 70. Hence, the investigation also accordingly, considering all factors and circumstances, non-bailable warrants are issued against Mandal. No attempt by the police either to issue.
Let us see section 75 first.
Yes, please have it. I got it. This time I carried my own.
Previously it was 73. Now it is 77.
It is. Just aside from this, a good way to remember the corresponding provisions, except for the first chapter from investigation onwards, is that it has increased by 20 sections. So 173 has become 193, then 223 is the cognizance from 204. So that part onwards from investigation has increased 20 by about 20 sections, my lord. So for us to correspond, because we keep going back, so about when we are searching, so 20 section, hence, my lords, we take that, my lords. But this has remained the same because it's
75.
75, my lords, please, may I place the 75? Warrants may be directed to any person. The chief judicial magistrate or a magistrate of the first class may direct a warrant to any person within his local jurisdiction for the arrest. Now, please mark, these are the criteria, my lords, of an escaped convict, proclaimed offender, or any person who is accused of a non-bailable offense and is evading arrest. Conjunctively, my lords, and is evading arrest is the criteria for this. So straight away, on the date that the FIR is registered, an application is made that, look, this person has fled the country, etc. He's not.
That day they don't even say that.
All right, sir. That this person's, according to this, is not available, and therefore, please issue the non. Now, why it assumes importance, my lords, legally?
There are three conditions.
Yes, my lords.
As it appears from 75(1).
Lordship pleases.
First is
Escape
convict. He is not escaped.
No, my lords.
Proclaimed offender. He
No,
was
my
not proclaimed offender under section 84(3)
Lordship
or
pleases.
84(4). But of any person who is accused of non-available offence
Yes.
and is evading arrest.
And is evading.
Why this will not apply?
Because he's not evaded, it's the same day. What steps did the police take, my lords, to actually secure my presence?
Because you yourself has admitted in the petition that you are out of country from 23rd of May.
But still, my lords, even then, there first some notice has to be issued for the police, some pasting that you are required to appear before the IO. I don't appear for the IO.
But, such procedure is not contemplated under section 75.
Straight away, it can't be, my lords. That's what the Supreme Court, I'll place.
But where is the prescription of law under section 75?
No, evading is when the police has exhausted the steps. This is by the court. And when your lordship sees the Dawood's judgment, my lords, the manner in which it is read that at the stage of investigation it comes is because it is an extraordinary step that has been vested with the judicial magistrate.
But notwithstanding the judgment of Dawood Ibrahim Kaskar.
Yes, my lords.
And if this court independently considers section 75 subsection 1.
Yes, my lords.
Then any person who is accused of non-available offence and is evading arrest.
Yes, my lords.
It appears that he was evading arrest.
No, it
He
can't.
was out of country
My lords,
from 23rd of May.
With respect, my lords, this IO has to say and mention the steps the IO has taken to secure my presence. He can't rely on and assume that I have evaded arrest.
No, I am asking.
Yes, my lords.
That if that would be an empty formality in the present case.
Yes, my lord.
Had IO took steps to nab him.
Yes,
to find him out.
Yes,
why? Because it is admitted in your writ petition that he was out of station from 23rd of May.
So, but lords, on 23rd of May, neither this FIR was there, nor was any steps being taken by the IO to in any other FIR to secure my presence. I can understand the IO delineating in his application that, look, sir, I have served him so many notices. He has not appeared in this particular FIR, that particular FIR. If he had pasted one notice, same day, my lords. And why is this done? Please see this. Why is this done? Warrants. Because the moment these non-bailable warrants are issued, my door to get anticipatory bail is shut. The moment it is done. This is the mischief that has been done with respect, my lords. To close that right, even if I wanted to come back on 23rd, had he secured me, sent me notice, I would have come and I would have filed for anticipatory bail and said, look, sir, please see me. I was in the day, whatever merits I would have argued. But to shut that door on the same day as the day which is the FIR is registered, non-bailable warrants, and on the saying of the IO, the magistrate has to apply his mind. He's not a post office that he sits there and whatever the IO says that he's going to go by it. He can't. The application has to say that on which date was what did he try to send me notice? On which day was I called? On which day I did not? And assuming he's talking about other cases that are registered against me, even then, my lords, he has to say that in these other cases, I tried to secure his presence. On such days, I sent him a notice. On such days, the person was absent, and therefore I fear that I can understand that procedure being adopted. But straight away, not even a day, only a matter of some hours on the time when the person is produced for remand. Non-bailable warrants it can't be done, my lords.
From the facts emanate from this petition, it appears that exercise would have been an empty formality.
Maybe, my lord, but something is required to be done.
It would be futile.
But how do, my lords, I ask myself, how do we know it would have been? Had the IO sent a summon, I may have come back. I would have come back. I would have applied for anticipatory bail. I would have moved it. On this day, on 30th is the day of the FIR. Please bear that in mind, my lords. On 30th itself, if the IO does this, my right to anticipatory bail is closed, and that is exactly why it is done. Look at the great alacrity with which the IO is moving in this, against me to seek non-bailable warrants without any material being there. Now, he has other powers. He has every power under the sun, my lords, to secure my presence. Every power. Search, seizure, notices, etc. Only after that, and this Kaskar that is relied upon, Kaskars is
That is 167/309 order that I.
my lord. So therefore, just rely. That is the only thing. The magistrate's application of mind is only for Kaskar, because Kaskar is a completely different, and even Kaskar says.
No, but the thing is this, that you are not in a position to cooperate with the investigation because you are out of
But
country.
how does the IO know that, my lords? How does the IO? What steps did he take? You lordships may ask them. Did he take any step 1, 2, 3?
Mr. Mitra, do you have whether any application was moved before the court below, that additional Chief Judicial Magistrate Shuri?
Yes.
Under section 75?
Yes.
Copy is there?
Yes, yes.
Where are the copies?
Application.
Give a copy for my, this is one copy you have.
Or the Advocate General has handed over. Same copy.
Same copy.
I mean, as in same document. Yeah, same.
আমি দেশে বাইরে গেছে না চিকিৎসা করো
But this court is telling that is reflected from the application.
Well,
of the
then the
IO said that he was perhaps out of state. Then it was stated no, as per leads or as per the interrogation with other co-accused, it appears that he is out of station. So to ensure his presence, warrant of arrest is required.
Because there are two schemes under this.
The court is saying that how his presence before the investigating officer can be ensured.
Why? Because the summons are issued. The summons are issued to the person. They are pasted at they'll be delivered at his residence.
To whom summons
at his residence, they'll be delivered the same way to the warrant.
He is not there to whom his summons would be
The warrants are also in the same fact, my lords. The warrants also have the same thing to whom. If he's not in the country, my lords, there's no way the warrants can be executed. That's the same the logic would apply, but he makes no attempt. Please see 175. It's power, my lords. The reason is because once in non-cognizable cases, the IO needs the permission of the magistrate to arrest. He needs a warrant. In cognizable offences, my lords, the IO does not need the permission of the magistrate to do anything. And I mean anything. And therefore, without doing those things, why rely on the crutches? Please see through. Lordships had cited Muhammad Wajid last time. It fell from my lords, Muhammad Wajid last time, my lords. Why is he doing this, my lords? Your lordships may ask that. Lordships may not let the state get away so quickly, my lords, by saying the IO says, every case the IO will write, I fear that he has fled from the country. I will not take steps. You issue non-bailable warrants. In every case, my lords, the right of the citizen to apply under anticipatory bail, the door will be closed, my lords. On the same day, can't he wait a day, my lords? Not one day. Same day, my lord, same day. What is the great hurry? And if I fled, I can understand if I was
7 days, it would have been done. Petitioner would have come.
he would have, we don't know, my lord, had he done it? We don't know. I would have applied for anticipatory bail. Now the door is foreclosed completely. Because I can understand him applying for warrants if he feared that I was going to flee the country. If I was going to flee the country, then I can understand him applying for warrants and saying, no, please execute these warrants. I'll execute it immediately. If according to him, I might, is the word that he uses, I might be abroad, then what are the warrants for, my lords? It can't be executed in any case. Well, let's kindly consider, please see the judgments. Judgments say this is a very serious thing that the magistrate is doing. And if the magistrate is doing it, can't be done at a mere ipsi dixit of the IO. And not in a light manner, because this curtails the liberty of a person under Article 21. Those are your lordship's judgment, this honorable court and the Supreme Court, my lords. All are.
But at the same time, IO has the authority to investigate the case.
No
if there is no cooperation on the part of the petitioner and he fled away, and the IO will say, will be a mute spectator.
My lords, but when, my lords, please bear the timeline. 29th, 30th are the raids. 30th is the FIR, 30th is the non-bailable warrants, 10th is the proclamation. Please see the speed. If the IO moves at the speed, or the Calcutta, the state police moves at such a speed in every matter, I would be very happy with it, my lords.
Court will also expect that in other matters also investigations.
But your lordship's experience may be otherwise.
Such a pace.
Your lordship's experience may be otherwise, sitting in this jurisdiction. And in my experience, it is otherwise. Matters after matters, the IO does not do anything. But it can't be, my lords. It can't be done to foreclose my right, is what I am saying. The Supreme Court judgments are clear, my lords. The High Court judgments are clear. And the application does not mention even one step taken by him, and straight away for non-bailable warrants. Straight away for non-bailable warrants, my lords. Not one step. Your lordships have seen the letter, that his application, nothing is mentioned in this. And in such a situation, I require NB. The magistrate should have asked him, have you taken any steps on your own? That is what the magistrate is meant for, my lords, not just to apply. Yes, all right. Kaskar says that, Dawood says that, yes, you can do it. Please see Dawood Ibrahim, your lordships have seen it many times. Please have a look at it. If there is any legal submission that can come from the state which justifies this action, or any judgment says straight away you can issue non-bailable warrants, my lords, then your lordships may dismiss my petition. Not one. I have done a research on it, not one. In fact, it's quite the contrary, that this is an extreme step, should not ordinarily be resorted to, violates Article 21. There is a balancing act that is required between the state, what is falling from your lordships, and that of the liberty of the individual that is falling. It has to be a balancing act. Now, if the question that is falling from your lordships is, wouldn't it have been an empty formality? Wouldn't it have been, had he done so? But he's still required to do so. That which is required to be done by him, my lords, has to be done.
Such formality is not envisaged under Section
It is evading arrest. That evasion has to be in this FIR, my lords. That evasion of arrest has to be in this FIR, my lords.
What more is required to be inferred when a person has fled country from 23rd of May?
But my lords,
it is evasion. If it is not evasion, then it is what?
My lords, it's falling from your lordships that I have fled the country, my lords. I have gone from this country. There is nothing that is there against me on that.
And you have gone from this country in May.
Yes.
This raid was conducted on 30th of July.
Yes, my lord.
May, June, July. You are roaming around. Last occasion, Mr. Davi, you have said what you are doing there.
Because I am abroad.
For what? What is the purpose?
My lords, a citizen has a right to be abroad, my lords. Is there any outstanding
No, but when there is his presence is required in terms of law, in connection with an alleged offense, then he has to before the court.
So, but when do I
justify that why he is for 3 months out of country?
My lords, with respect, my lords, on the day I went, there is not a single warrant.
Simple citizen or general citizen, nobody will ask.
My lords,
but against whom? When a criminal prosecution has been initiated, then why he has fled, that has to be clarified.
I can flee if it would be counted as fled, my lords, if on that day there was a warrant or any proceedings that were there against me. There has to be something, then that gives me the apprehension.
Yes, there were proceedings.
No, my lords, there were none.
There were other proceedings.
No, my lords, there were none.
In the month of May, there are other proceedings initiated.
That chart I showed to your lordships last time.
See
that chart that I...
See that, Mr. Dave?
19/5/26.
In the month of May, there was a proceeding.
That yes, lords, proceeding is that there is an FIR that is registered.
Yes.
Not asked, not summoned, nothing done on 19th of May till 23rd. I do not know when an FIR is registered unless I am summoned, my lords. On 19th, nothing done. 20th, 21st.
So 19th, when FIR was registered?
So that was...
And 23rd, you fled?
Yes, my lord, an FIR is for an incident of 2021. The FIR, that 19th FIR is for an incident of 21. That means after 5 years, my lords, I would think as a person, as a citizen, please wear the hat, my lords, of the citizen for once, my lords, and ask that what was the citizen supposed to do?
If it would have been vexatious complaints or case, then why you have fled?
My lords, that's what I'm saying. I have not fled. Fleeing is when there are some proceedings that are pending against me. If there is no proceeding which is pending against me on that particular date, my lords, it can't be said that I have fled.
No, FIR was registered on 19th.
But how does a citizen get to know, my lords? Some summons will be served, given the manner in which they would have got non-bailable warrants on 19th itself. In that FIR, they don't do that. Milord, is there, please ask.
Yes, any other point?
Milord, is there any proceeding, Milord, that is there against me on that particular day? How do I get to know that there is an FIR as a citizen, Milord? As a citizen, unless and until as there are summons issued by the police or the police comes knocking on my door, they don't do anything. If they register an FIR and keep quiet, my lord, there is no way a citizen is going to know that there is. He's not going to check, my lords, with respect the portal and see whether there is an FIR against him for an incident. Please bear this in mind, my lords. It assumes importance. For an incident of 2021, that is 5 years hence. It is not something in immediate that he would think that yes, it can be done. So now, my lords, if there is no proceedings and you foreclose, the state forecloses the right. Had they sent a summon, I may have come back, availed of my remedies and applied for anticipatory bail. After all, I filed my writ before your lordships, my lords. I filed that writ. That writ was filed, my lords. Kindly see on 4th of August, my lords.
The moment I came to
I filed it. I'm submitting to the jurisdiction of this court. It's not that I have gone away and I'm not doing anything or opposing some grant by
Who has affirmed this affidavit?
Who has affirmed it?
Must be an authorized signatory.
Who's affirmed it?
my sister.
And that
Sister.
And that writ petition order is passed.
Sister.
Filing of writ petition, can it be a ground that he has not played?
No, my lords, I'm saying that I have acceded to
Mr. Dabe, who
his
affirmed
sister,
this affidavit?
sister. The
He
pair
was,
of
not, he was not in the country, not in the within the jurisdiction of the police station.
Please appreciate, my lords.
And you cannot take advantage of your absence in the country by filing a writ petition, and that too which was dismissed.
No, I'm not taking. I'm saying I'm submitting to the jurisdiction of this court. I'm recognizing it. It's not that I fled. I wouldn't have done anything. I have gone abroad. I would have stayed abroad, my lord. There is no need, as is falling, lords, from your lordships, that the police has done this because you have fled. How does one flee? If I suppose tomorrow Mr. Dave goes for a holiday in October and I find out after that there is an FIR
He
against
goes for holiday for 3 months.
But why not, my lords? People go for 6 months, 9 months, my lords. They go for a long time. Holidays are a good thing, my lords. We don't get holidays that much, my lords, but people their businesses are running, they go on a holiday, my lords. But in this case, have I evaded arrest?
But at a juncture, you have left the country.
Yes, my lords.
It questions many things.
No, I am not.
Speaks volumes.
So, my lords, what do I do today? What is the option against me? If I come back, which I want to come back, I can't apply for anticipatory bail. That is foreclosed. That can't be done. Since the question is why not, I'll explain to them. If non-bailable warrants and proclamation proceedings have been initiated, then anticipatory bail is no longer available. So what do I do, my lords, if that is not there?
Section 75(1), yes, evading arrest, as you are submitting, correct that it was done in hot haste. But had the petitioner been in the country, then question would have been different.
So I'm saying I want to come back. I want to come back, my lords. Not that I want to stay there. I want to come back. But your lordships may have
in the given situation, court will not pass any order which will make a ground so that you will come back and you will not be interrogated.
No, please interrogate me as much as they want to their heart's content. I don't even know how many FIRs now must have been registered against me. This is only
but in this criminal revisional application, this court is not.
Your lordships do that, my lord.
Trying to pass an order for giving you protection. Then in the writ petition, court would have passed this order.
But that day when I wanted to argue both, it fell from my lords, my lords.
Yes, that I remember.
So I wanted to argue that this also on the same day, but I took a little bit of more time than I should have taken in that matter.
No. Also, court was constrained. So for other matters,
Yes, so my lords, in this also it can be done, but these proceedings which I have challenged directly, the hot haste has fallen from your lordship. I come back, I have no joy in staying there. My brother is under arrest, my businesses are being attached, my residential house is attached, all that was challenged before your lordship. I want to come back, but come back doesn't mean, my lords, that immediately come to be arrested. I have certain remedies in law.
Any other point?
Because I have certain remedies in law which have to be exhausted. Now, if your lordships don't stay this, then I can never come back. I'm making a statement, I want to come back. But with these 82 and
For ensuring your coming back, court will not interfere on this order.
No,
That
not for
cannot be
ensuring.
done.
That
will encourage similarly placed other accused.
No, my lords,
First go outside the country and then
my lords, when I
then put the investigating machinery
into
a challenge.
Both facts are being put against me. That you fled the country when there was no proceeding, and the second one that I want to come back.
Then fleeing country by these persons who are accused in a criminal proceeding will be encouraged.
But my lord, there was nothing then, my lord. Please just ask them.
Then this court has to pass an order. Yes, please, you come back and no steps will
No,
be
on
taken.
my undertaking. On my undertaking, my lords, on my undertaking, your lordships may do
You
that.
have done a great job that you have left the country. Please come back and no steps.
So,
will be
but
taken.
come back, but my remedies can't be blocked, my lords, by them. In that, now just see
That's
the.
all.
Oh, just your lordships are inclined to see the law on this, my lords. What is if the trial judge's order issuing non-bailable warrants?
Show me any proposition that when the accused is out of the country at the time of interrogation, then this section 75 cannot be pressed into service.
The first one.
Not other judgments. Please show me the relevant judgment that accused is outside the country at the time of interrogation when proceeding is initiated, and for that and in that context, section 75 cannot be pressed into service. Not beyond that, I will not permit.
Because in Dawood, it had happened. It's a fact. The facts are.
I will not rely upon Dawood. I will rely upon 75 and the very fact that you have fled the country. I will not pass.
But the magistrate himself relied upon. We are challenging that order. If the magistrate relies upon a decision of Supreme Court which is wholly inapplicable, my lords, then the magistrate needs to revisit.
Clarify it.
The magistrate has to clarify it, my lords. My lords, with respect, your lordship.
Yes.
With respect, my lords, your lordships may not be in a position to clarify it because it's his application of mind. A superior court cannot clarify. It can be set aside and remanded back for his application of mind, my lords. But a higher court cannot substitute its opinion for the opinion that was formed at the first stage. That is why, my lords, that matters are remanded. Suppose there's a cognizance taken. Cognizance order is challenged. The higher court doesn't, or no cognizance is taken. Higher court cannot say, I will take cognizance even though this. It can't be. It is remanded back to the person, the judicial officer who's performing that. It's his discretion. Now, if he relies on Dawood, which is wholly applicable and inapplicable, and I'm challenging
under
that.
528, this court has power.
No, my lords, with respect, 528 doesn't apply. With
This
respect,
is an application under 528 vis-a-vis, yes.
It can't be, my lords, against me. 528 is meant for preserving those rights which are there. In my petition, my lords, your lordships are inclined to clarify the position of the magistrate, which magistrate has committed in my respectful submission, my lords, a complete
These are under section 438, 442, 528.
Yes, of course, we have to invoke those provisions, my lords, but it's a blunder by the magistrate in issuing the hot haste. Please appreciate that, my lords. If this be the case,
I have heard you regarding your point.
So this is that
very well. Please.
The judgment in Dawood is on that, my lords. How does it apply?
Only on this point, not beyond that. I will not
we are on evading arrest is what has happened.
In the same set of facts, you have to show me that a person is out of country and has fled the country, but section 75 cannot be pressed into.
He may have fled the country, my lords. He may be abroad for 6 months. But has he evaded arrest is the question. The section doesn't say anything about fleeing the country or being abroad. Section says evaded arrest. What steps in this letter that is written, my lords? My lords, which part of this letter that your application that your lordship says has he come to the conclusion that he has evaded arrest? That is, where is it reflected that he has evaded arrest in his application? That I took these steps, sir, I have not been able to secure his presence and therefore he is evading arrest.
So-and-so person has fled from the state and
No,
during
fled is going
his
abroad.
flight conducted today, he was not available in the house.
How?
It
It's
further
not his house.
transpired that he might have left India in the month of May 2026.
It's not his
which
house.
is corroborated
It
by
is
your
not his house.
statements in the
All
petition.
wrong, Biloj. It is not his house. It is not his house, so he's not bound to be. If it's not my house, I'm not bound to be in that.
Whether he was in his house.
I'm saying he was not in that house where it was there. The raid took place, my lords.
Yes.
Now, if they, whereas he said that I have taken these steps, they have come to a knot, and therefore, I think he is evading arrest. I have taken those steps.
And it is evident that for the best interest of the investigation, he is required to be interrogated in person, keeping him in custody. Yeah, it is also futile, further evident that in order to frustrate the investigation, he had fled from his all possible hideouts.
This does not stand to reason with respect that a person who leaves on 23rd of May will have some clairvoyance in his mind, my lords, or be a clairvoyant that in August there will be an FIR registered against me, and on the same day a non-bailable warrant. This is putting the cart before the horse, my lords, with deepest of respect. This can't be permitted for the state to take action
And the
like this.
point taken in the petition that he has not fled, that should be inferred from the very fact that a writ petition has been filed by the.
But we are submitting to jurisdiction.
That is the ground.
But
first
correct,
ground.
with respect, that's a correct ground, my lords. With respect, I'm saying so. I am acceding to the jurisdiction.
Filing of this writ petition, Mr. Dave cannot come in favor of a person who has fled the country and who is the
But
prime
my lords,
accused in a
please
criminal
ask, my lords, please ask from 19th of May till this non-bailable warrant was issued, did they take a single step to arrest me? Please ask them one step that they have taken to arrest me, my lords. One. I sent these notices. I asked them to come. I pasted a notice outside his door in some other case. Which case did they do so? One, my lord, something for fleeing.
It is nothing but staying in the foreign country. It is one after another attempt to protect.
When there is no FIR, my lords, there is no FIR, my lords. I'm trying to persuade your lordships, my lords, to come to a conclusion that if there is no attempt by the police officers to arrest or do anything, and I go abroad, I'm not even aware for a 5-year-old case, then how is it fleeing, my lords? With respect, how does this IO overnight come to this conclusion without any steps being taken? If he had delineated here, I served a notice under 160, I asked him to cooperate, I asked him to come, I can understand that. Does nothing form this conclusion that, oh, I don't think he's going to come. In my mind, he's trying to evade because he's not here. So please issue non-bailable warrants. That is the conclusion. He's reached the conclusion without going through the steps. Now, please see the out, my lords, in these facts. I can only persuade your lordships, my lords, to see from a citizen point of view, whether he be accused, he still has his rights under 21, that you can't straight away issue of non-bailable warrants against an accused. Accused has certain rights, and non-bailable warrants are of having consequences. Had he said so, had they done, let them show one document, my lords, to your lordship. One notice, one summon, one something to say that I was trying between the 23rd of May till this FIR is registered, I was trying to evade arrest, which is what the section requires. One. If they have it, they have taken steps, not in this, in other cases also. They say they've registered 6.
If I stay this order and direct the IO to take steps, then what steps he will take? He will ensure his
He'll
presence
issue summons
before
to He'll issue summons to me.
The summons would
He
be
will
issued.
go and paste the summons at my residence.
Where is the what about the whereabouts of that petitioner?
He will pay, my lords, the same way. How do
Please tell me where
I'm
with
answering the
regard to
question.
whereabouts of the petitioner?
My lords, the same way these warrants will be executed. Can he execute these warrants then? If a person is abroad, that the hot haste in which he's done. Why is it doing? Therefore, I started. Why?
No, that's why court is asking that there are certain steps which are required to be taken in between or prior to issuance of warrant
Yes,
of arrest.
he would have.
What are the steps? And
He would have issued summons.
Those steps are going to help the investigating officer
has to
get his presence before him.
He has to issue a 41 notice.
Interrogation.
Because a 41 notice is mandatory.
Whom it will be issued?
It will be issued to his residence. Somebody would.
He is not staying at
Maybe
his residence.
somebody would have.
Then he will again come back. Yes, it was not served upon me.
No, because whether in that when 41 notice is issued, somebody will inform him there is a 41 notice against you. He will get a copy. He will come, or he would apply for anticipatory bail. He'll say, "Look, sir, I'm not involved in this case." But without any of those steps, no 41, nothing of those steps being done, my lords, straight away. warrants are issued, non-bailable warrants are issued by the magistrate without any reasoning except for Dawood, and no application in the, no mentioning of any facts in the. Now, please see Dawood. In what circumstances did the Honorable Supreme Court, my lords, consider it?
Handed over compilation. Is there.
Please see the principal question itself, which is at page 3 of the compilation.
Because we have handed over compilation.
Sorry. Lordships, has Dawood Milaj the first judgment?
Page 3.
Starts at page 1 of the compilation.
Yes.
Principal, page 3, my lords, the principal question that is required to be answered in these, is when and under what circumstances can invoke the
Page 3,
page 3, the first opening line, my lord, Justice Mukherjee's judgment. Principal question that is required to be answered in these appeals is when and under what circumstances a court can invoke the provisions of 73. This question arises this way.
Yes.
Lords, para 4. In the course of such investigation, CBI apprehended Mira Moinuddin Sheikh on the absconders mentioned in the charge sheet. He made a confessional statement before Sri Saikia, Deputy Inspector General of Police, Ahmedabad, which was recorded by him on 8/8/95 and 19/8/95 under Section 15 of TADA. In that confession, he disclosed that respondents number 2 to 7 hereinafter referred to as respondents, had taken active part in the criminal conspiracy, which was a subject matter of this called bomb blast case number 1. Thereafter, 22/5/96, the CBI, now please mark these dates. Thereafter, 22/5/96, the CBI moved an application before the designated court. So a period of 19/8/95 and 18/8/95 and 19/8/95 to 22/5/96, not immediately. CBI moved an application before designated court wherein it was stated, following the disclosure of the involvement of the respondents in the offense in question, raids had been conducted at their known hideouts to arrest them, but none could be apprehended in spite of the best efforts, as they were deliberately evading their arrest to escape the clutches of law, and accordingly prayed for issuance of non-bailable warrants of arrest against them to initiate further proceedings in the matter, to apprehend them or to take further action to declare them as proclaimed offenders. 2 other applications were thereafter moved on 3/6/96 for publication of written proclamation under Section 8(3) of TADA, and also for issuance of open-dated non-bailable warrants of arrest, so that red corner notices might be issued against them. According to CBI, such notices are required to be got by Interpol. Now, my lords, all this happens as far as the court is concerned. It was issued, and the designated court, paragraph 6, my lords, at placitum D, relied upon a judgment of the Bombay High Court. Your lordships have the words in italics. Just before that, at placitum D, according to the paragraph 6, my lords, placitum D.
Yes.
According to the designated court, though under the code further investigation was not barred, there was no provision therein which entitled the investigating agency to seek and obtain aid from the court for the same. Since the above findings were recorded by the designated court relying solely on the judgment of Bombay High Court in Muhammad Ahmad Yasin, it will be necessary to refer to the same in some details. I'm not referring to it because the judgment overruled it, my lords, as far as Mansoori's judgment is concerned. Then comes the law laying down, my lords, from paragraph 7 as to what is the procedure as far as investigation is concerned. In view of the provision, paragraph 7, my lords.
Yes.
In view of the provisions of chapter 12 and those of 3092 of the code, we are constrained to say that the above quoted observations have been made too sweepingly. Chapter 12 relates to information to the police and their power to investigate. Under 154 thereof, whenever an officer in charge of a police station receives an information relating to the commission of a cognizable offence, he is required to reduce the same in writing and enter substance thereof in the prescribed book. Section 156 invests the officer in charge of a police station with the power to investigate into cognizable offences without the order of a magistrate. And 157 lays down the procedure for such investigation. In respect of an information given of the commission of a non-cognizable offence, the officer in charge is required under section 155(1) to enter the substance thereof in the book so prescribed, but he has no power to investigate into the same without an order of the competent magistrate. Armed with such an order, the officer in charge can, however, exercise all the powers of the investigation he has in respect of a cognizable offence, except that he cannot arrest without a warrant. That is what, so it's delineating the principles, my lords, as far as cognizable and non-cognizable. In non-cognizable, you'll have to go there. And this is why it turns, my lords. This is why the judgment holds that since the
Bombay High Court, they are held that after completion of investigation,
Yes.
there is no scope.
Yes.
Then the Supreme Court held in this
Yes.
that even after completion of
Yes, my lord.
investigation at the trial stage,
Yes.
since in terms of the prescription of law,
Yes.
the accused is required to be produced before the
Yes.
court,
Yes.
then this is permissible.
Yes, my lord.
That is the crux of the issue.
Yes, that is.
Yes.
But it turned, my lords, on this basis. The reason
This is not going to aid the facts which this court is dealing today.
No.
You are taking a point, Mr. Dave, that yes, in hottest, within 1 day, entire process was complete.
Same day.
That is not the requirement as contemplated under section 175.
Yes, my lords.
Now, if the requirements would have been followed,
Yes.
effect would have been same because he has fled the country. That answer I will not get from Dawood Ibrahim Kaskar.
But it's the same facts, my lord, similar facts. They had done exactly the same. Those respondents were not in the country. But please, that's why I read paragraph 3. 18.895 is the confession. 19.895 is the confession. Your lordships will find paragraphs placitum D. And thereafter, what did the CBI do? Till 22.596. The CBI waited to move this application. In the interregnum, what did it do? Wherein it stated that following the disclosure of the involvement of the respondents in the offence in question, raids had been conducted at their known hideouts to arrest them, but none could be apprehended in spite of best efforts as they were deliberately evading their arrest to escape the clutches of law. This is how evasion comes, my lords, that you exhaust all the remedies that you have, the police, and then come to the magistrate, not the other way around. That in my opinion, sitting in a police station, in my opinion, there's no point. Why should I be? Why else is a police officer vested with these powers under 156(3), my lords, in 154, 156(3? There are certain guidelines that are there which are inherent in the statute itself. For a non-cognizable offence, there is no requirement for him to move the magistrate till it is the very last resort. That is the difference between cognizable and non-cognizable, which is what the Supreme Court says. Magistrate is out of the picture except for arrest and remand under 167 and considering bail. That's the Rishbud judgment, my lords, 1955 Supreme Court. Well laid down, well followed, my lords, by a lordship's court, by all courts in India. But it can't be, my lords, that the IO comes to this conclusion beforehand itself. I'm saying even here, for a case of bomb blast, for a bomb blast case in which over 200 people lost their lives, the CBI waited. They knew it was based on a confession. Like in my case, confession is the same day, FIR is the same day, NBW is the same day, everything on the same day, on the ground that the IO feels somehow that, look, I don't need to follow these things, these steps. It's a futile exercise for me, my lords. Would your constitutional court, my lords,
Because petitioner was not there in the country. Still he is not there.
There are FIRs after FIRs that are registered.
The court can ignore this fact.
There are FIRs after FIRs that are registered, my lords, where people are abroad. But there also securing presence is done by the IO, and NBW is the last stage that is resorted to, my lords. And for the reason why he has done it is he wants to foreclose my right of applying for anticipatory bail. I'm making that statement, my lords. In law, that is why he's done it. Otherwise, there is no good reason. How would he execute this non-bailable warrants, my lords? I ask myself, if I fled the country, what would happen? Nothing.
Page 13 on the company.
Second, Baba, develop to come near the please. How would it be executed? If the IO feels, my lord, his summons can't be executed because I have fled the country, how would the non-bailable warrants be executed? He'll execute it in the same manner. He will go by giving a report, which is the next order on the file, my lord, which we have challenged, saying, sir, you had issued these non-bailable warrants against this particular person, and those non-bailable warrants are not served because the person is not here. So now kindly issue proclamation against him. And it's in these circumstances, my lords, that the Supreme Court in paragraph 21 first deals with section 73.
Yes.
Page 12, my lords.
I will hear up to 3. Then I will adjourn the matter because other matters are to be taken up. Then I'll fix up a date.
Lordship, please. 21, my lords. Page 12, para 21. My lords, your lordships may hear the matter as per your lordship's conscience. Whatever. If your lordships wants me to sit down, my lords, I will not press further.
But I'm telling you that.
But I'm only making. Please, my lords, your lordship's court, my lords, let it be conducted in the manner your lordship conducts, not because of I am here or anything, my lords, or I'm pressing too hard in a particular matter, my lords. Let that not be the ground, my lords. Page 12, para 21. I have the highest respect, my lords, for your lordships. Whichever, I know there are a lot of matters, your lordships with great difficulty take out time in these matters. This matter, some other matters, my lords, with a change of political, we also see, my lords, on somewhere or the other, something comes, we also see and read about them. They occupy a lot of your lordships' time. It is there. Para 21, that section 73 confers a power upon a magistrate to issue a warrant, and that it can be exercised by him during investigation.
Paragraph 21.
Para 21.
Yes.
That section 73 confers upon a magistrate to issue a warrant, and that it can be exercised by him during investigation also can be best understood with reference to 155 of the code. Please mark this, my lords. As already noticed, under this section, a police officer can investigate into a non-cognizable case with the order of a magistrate and may exercise the same powers in respect of the investigation which he may exercise in a cognizable case, except that he cannot arrest without warrant. If with the order of a magistrate, the police starts investigation into a non-cognizable case, non-bailable offense like 466, 467 of the Indian Penal Code, and if during investigation, the investigating officer intends to arrest the person accused of the offense, he has to seek for and obtain a warrant of arrest from the magistrate. If the accused evades the arrest, the only course left open to the investigating officer to ensure his presence would be to ask the magistrate to invoke his powers under 73 and thereunder those relating to the proclamation and attachment. In such an eventuality, the magistrate can legitimately exercise his powers under 73 for the person to be apprehended is accused of a non-bailable offense and is evading arrest. Another factor which clearly indicates that 73 of the code gives power to the magistrate to issue warrant of arrest, and that too during investigation, is evident from the provision of Part C of Chapter 6 of the Code, which we have earlier adverted to. Needless to say, the provision of proclamation and attachment as envisaged therein is to compel the appearance of a person who is evading arrest. Now, the power of issuing a proclamation under 82 quoted here and above can be exercised by a court only in respect of a person against whom a warrant has been issued by it. In other words, unless the court issues a warrant, the provision of 82 and the other sections that follow in that part cannot be invoked. This is why I argued this.
It is provided in 85.
This is why I argued. This is the reason why on that very day this NBW is done and within 10 days proclamation is done. This is the reason. It's a precondition. They are not interested in securing. They are interested in attaching my properties, which is what I had argued in the other petition in that writ, that you can't attach a residential house, you can't attach everything. The interest is not to secure, interest to attach all the properties, make it. So this is the Supreme Court was conscious of it even then, that if this is a precondition on 82, and that is exactly why this comes. So therefore, power to issue warrants at the stage of investigation is available. But available when, my lords? For what? because you have to do attachment, etc., for a person who is evading the arrest. We'll keep circling back, my lords, to the same question, my lords, where I would submit to your lordship. I'll read that 24, where I'll submit to your lordship, my lords, he did not evade arrest because no steps for his arrest were taken by the IU. That is what my submission is in one line, my lords. There was no evasion of arrest because the IU had not taken a single step to secure his arrest. Merely by the fact that he was abroad does not mean that he was evading arrest.
Para 24 is very important.
Yeah, I'm reading it.
So this I was not actually.
Yes. Now please have 24 at page 13, my lords. Now that we have found that 73 of the code is of general application and that in course of the investigation, a court can issue a warrant in exercise of power thereunder to apprehend, inter alia, a person who is accused of a non-bailable offence and is evading arrest, we need answer to related question as to whether the issuance of warrant can be for his production before the police in aid of investigation. It cannot be gainsaid that a magistrate plays not infrequently a role during investigation, in that, on the prayers of the investigating agency, he holds a test identification parade, records the confession of an accused or the statement of a witness, or takes or witness or specimen handwritings, etc. However, in performing such or similar functions, the magistrate does not exercise judicial discretion like while dealing with an accused of a non-bailable offence who is produced before him pursuant to a warrant of arrest issued under 73. On such production, the court may either release him on bail under section 439 or authorize his detention in custody, either police or judicial, under 167 of the code. Whether the magistrate, on being moved by the investigating agency, will entertain its prayer for police custody will be at his sole discretion, which he has to be judicially exercised in accordance with section 167(3) of code. Since warrant is and can be issued for appearance before the court only and not before the police, and since authorization for detention in police custody is neither to be given as a matter of course nor on mere asking of the police, but only after exercise of judicial discretion based on material placed before him, Mr. Desai was not absolutely right in his submission that warrant of arrest under 73 of the code could be issued by the courts solely for the protection of the accused before the police in aid of investigation.
What is wrong with you? This is investigation.
So this answers. Here the police says that this person is evading arrest. You issue the warrants to the magistrate. The magistrate issues this warrants. For what purpose? Supreme Court says it's not for your purpose that it is doing. Not for, therefore it becomes incumbent upon the police for its own purpose, my lords, to take steps to arrest. And only upon failure of those do you come here, does the IU fall under 73. Please read those from Placitum E onwards once again, my lords. Whether the magistrate.
I can't be that. Together. Similar.
steps have to be taken.
It was not for the production of accused before the police authority, but before the court. And then under section 167, it is to be decided.
Yeah, it can't be only for the accused,
Yes.
for the police. That is what the Honorable Supreme Court says. Because once he is produced, then it's up to the magistrate whether to remand him into judicial custody or grant police custody, which the Honorable Supreme Court says that according to the discretion. In the present case, it is in aid of the investigation because it's the first day of the FIR, my lords. First day of the FIR, it is on the aid of investigation. There's no question of 167 securing his presence and asking that it be sent to judicial remand. There is no way. So here the application in the present case, my lords, is in a hot haste for this reason and hit by this paragraph 24, my lords, clearly and squarely. And if this be the reason which the magistrate adopts, then, my lords, with respect, the magistrate has not appreciated the reasoning of the Honorable Supreme Court. He could have said that let him come. I will see once he comes whether to remand him or whatever. He doesn't say. He said, I am issuing it. You go and serve the warrants for him. And that is why, my lords, this judgment, my lords, of course, I had the occasion for very briefly to appear before Justice Mukherjee. His knowledge of criminal law, my lords, is still we still sing very great songs about the knowledge, my lords. And we have page 100 now, my lords.
Just come back to page 6.
What is that, page 6?
Page 6, there is an observation of the High Court.
That's the judgment. That's the judgment which they overruled.
Just see what they say. Like this.
Even in terms of warrant of arrest, in terms of section 75, subsection 3, he is to be produced before the magistrate.
Yes, because it's the warrant under his hand. So the authority which issues that warrant is by his hand. If it is the police.
That's why the contention of Mr. Desai was negated to certain extent, as it is recorded in paragraph 24.
Bow down.
That it is to be that the accused is to be placed before the investigating officer. That is not the correct.
I bow down, my lords. I bow down. So please.
But how does it help you?
Because here it is only for himself, him. He doesn't want my arrest to be there for purpose. He says, I want it in aid of investigation, which the Supreme Court says no, because it's on the first day.
In that event, it can be clarified that the accused person, petitioner, can be placed before the magistrate.
No, he will have to place in any case.
Can be clarified that he is to be placed before the magistrate and he will apply his power under section 167.
Very well. Judgment says, my lords.
If I accept your contention,
Yes,
Mr.
it
David,
can't
that's
be.
why I am trying to understand your contention based on some observations made in paragraph 24. That yes, it is accepted.
Yes.
That the submission of Mr. Desai was negated to the extent that it is not a production before the investigating officer, but it should be the production before the magistrate.
Yes.
And magistrate will take a call under section 167.
Yes.
Whether he is to be remanded in judicial custody or police custody. Very well, that can be clarified, directing the petitioner to appear before the magistrate, and he will take a decision in accordance with law.
That is on the exercise of power, my lords. Supreme Court says the magistrate cannot exercise this power in aid of investigation. That is what the Supreme. It gives the reason why, which is the production before it, etc., are the reasons why.
According to you, production of the accused is permissible before the magistrate in reference to observations made in paragraph 24.
Yes.
Now, if it is permissible before the magistrate, considering your submission, as it is under section 75 also, it is section 75 subsection 3, that the accused is to be produced before the court, before the magistrate, then let it be complied with.
All accused are required to be produced before a magistrate.
Right.
All. He would be produced if arrested by IO under 167, and here he will be produced by the police after 75. But the difference is that under 167, if the arrest is under 167 by the police, for 167, that police arrest is there by the police themselves without the aid, then it will be have a period of holding for 24 hours, etc. That is one of the criteria. At minimum, just before 24 hours.
In 15 days, 60 days, 90 days.
I'm obliged.
Yes.
That is there. Here it is, can't use the court for, I know, Miloj,
It's carry on.
3 o'clock I've
I will
crossed.
try to conclude it, yes.
Miloj,
With your cooperation. Yes, let me see. Yes.
it's the,
Yes. No. Make your submission so that I can understand your submission.
So this being that aid, that it can't be in the aid of it, is what I'm saying is hit by. That he has to be produced by magistrate.
In reference to the in reference to section 167, what you are trying to say?
Miloj, that all accused who are arrested have to be produced before a court. Difference is here, there is no discretion to hold the person for custody. The moment the warrants are executed, you will take the person to the magistrate and say that, sir, I have got this person pursuant to your magistrate.
That is section 75, subsection 3.
I am obliged. So that is how it works, the differences. But the reason why the Honorable Supreme...
But in case of 167, 24 hours...
he will hold it for...
yes.
He'll hold for 23 hours, 59 minutes, he can hold and then produce. But the reason why the Supreme... 167 is only the reason the Supreme Court gives is that it is not in aid. It is not in your aid, is because you will have to take him there and produce before the magistrate under 167. It's not in your aid for investigation. Only after you've exhausted it, do you come to the magistrate. That is what is held, that after it has, and the magistrate will apply a judicial mind. Not necessary for the magistrate. You could reject the application. Magistrate is not bound by what the IO says that I'm trying to secure.
When the accused is not available. Now, yes, you are making the submission that no steps were taken to find out the accused and take him into custody for at least for a period of 24 hours and for compliance in terms of section 167. If that is not possible, then what was the course left open to the investigating officer? But in view of the situation that petitioner is not in country.
No, but Miloj, what I am saying is that the magistrate is not bound by the application of the IO. Magistrate can still reject it, saying, I'm not satisfied that you've taken adequate steps. Please go and do your investigation. Don't rush to me.
But magistrate is also empowered to accept the contention of IO.
Yes, but there he has to apply judicially his mind.
In the present situation, where is the wrong so far magistrate is concerned in accepting the contention of IO when the petitioner is out of country?
Because the magistrate doesn't apply his judicial mind to it. By asking the IO, what steps have you taken? That judicial discretion. I can understand if the magistrate did not cite this judgment. The magistrate is conscious of this judgment. Having been conscious of this judgment, which says it's a judicial discretion that you have to exercise at a last resort that you have to come to, the magistrate takes it as the first resort, which is my problem with this manner in which it is done.
With regard to this judgment, it can be clarified by this court under section
Well,
528.
there is
Under
one-
section 528 that it may not clarify squarely so far the present case is concerned, but the fact remains that the petitioner is out of country.
Maybe, Miloj, there are accused persons who are out of the country. And they go out of the country, they are out of the country. And there is Miloj, this doesn't mean that they are fleeing. Merely on that, Miloj, every IO will rush the moment they find out. It's the easiest thing. I have a cheating case against my friend. I will register. I know he's gone on a holiday during the Pujo vacation. I will register. He's gone on a please issue 73 warrants or 75 warrants. But it can't be with respect, Miloj. There are certain guidelines which have been laid down by Supreme Court. What is the haste, Miloj? Your Lordship, that question, the Your Lordship may ask them, what did you do for 1 day, 1 hour?
Let the petitioner appear before the magistrate and then I will direct that to exercise power under section 167 accordingly.
Well, just give me a moment.
Very well.
You stayed, I'll move my anticipatory, no? And appear, I'm ready to appear, I'm ready to make that
Yes,
statement.
Mr. Mitru, if okay, this order is modified to that extent that let the petitioner appear before the magistrate and then magistrate will take decision under section 167 BNSS.
Kindly give me, my lord, 15 minutes time.
What is your, I'll give him 15 minutes time or I'll fix another date, but what is your submission on this?
Miloj, I will appear, provided this is stayed, Miloj. It has to be stayed. I will appear on my own. At the same time, my legal remedies, all options may be left open for this. I will appear, no doubt about that. I'll appear. But it can't be that the moment I land from wherever I am and at the airport, my learned friends' clients are there waiting with garlands and everything and take me for it. Can't be. And an entire media circus is being created for it. It can't be like that. I will appear. I said it at the outset. I'm submitting to the jurisdiction of the courts. I'm a citizen of India. I'm not some foreign national. I've lived here all my life. I'm here in this state.
Just see the coordinated bench.
And your lordship, the one honorable single
To obtain instruction in this. Come back. Today I am adjourning the matter, fixing a date, and obtain instruction that what is your stand, what is the stand of the state so for appearance of the petitioner before the magistrate, and magistrate will pass order in accordance with law under section 167. As Mr. Dave is pointing out that yes, there is a difference in between 75 and 167 production. Issue.
Only thing, my lord, I can add for the time being is, my lord, whatever has been said today, those are not reflected in the petition. Sarcastic smile, I'm
not being sarcastic.
Somebody else from your side.
Yes, yes.
Now, I looked into the petition. The writ petition says I left India on 23rd of May. Where? No mention. Normally, my lord, we say that, my lord, I have been there. Why? No mention. Now, this petition, my lord, it was affirmed much subsequently. I looked into this, expecting that a statement would be made that yes, I had been there. I'm coming back. I want to come back. I want to abide by the laws of the land. No. Whatever statement has been made, my lord, today before your lordship are all from the bar. Petitioner, my lord, obviously. Kindly look into the first writ petition affirmed by brother. No power of attorney.
Writ petition.
The writ petition. Are brother to constituted attorney kagoj kothay? No, I don't think so. Jayu, very well. This is by the sister.
No power of attorney.
No power of attorney. And my lord, I shall make my submissions. My lord, your lordship wanted me to take instruction. I shall do. Definitely.
Because at the same time, his presence before the IO is necessary. If I was also thinking that today if I throw this revisional application, he will not come for 6 months, 1 year. Then no purpose would be subserved. At least let him appear before the magistrate, and then magistrate will take a call under section 167.
I shall ballot come.
I will appear before the IO. I will move my interest.
Only so.
Very good. Issue. Criminal revisional application is heard. Stop. Mr. Siddharth Dave, learned senior advocate, represents the petitioner and has made submissions. Stop. State respondents are represented by Mr. Surajit Nath Mitra, learned additional advocate general. Learned advocate general. Additional learned advocate general. Stop. In the writ petition, in the criminal revisional application, order dated 30th July 2026, passed by learned additional Chief Judicial Magistrate Shuri, Birbhum, in GR case number 1373 of 2026, connected to Mohammad Bazar Police Station, case number 267/26 dated 30th July 2026, is under challenge. Stop. Next, hearing of this matter stands adjourned. This the matter. Yes, when it will suit. Which date will be suitable? Both of you are asking.
Tuesday? Does Tuesday suit you, sir?
In the month of September, first week. This month, not possible.
Okay, nine.
Today is 27th, yes.
But Charya says, how about 9/11? All right, 9/11 is fine.
Proceeding of the trial court.
9th को ले रहे हैं ना 9th.
No, let it be a week earlier. I have to go up there to do something. Let it be second.
এই 9/11 ডায়েরি পজিশন কি?
What's the second?
কি আছে?
Second, the second.
মানে হ্যাঁ ঠিক আছে করা যেতে। On 9/11/2026.
11/9. That's the American.
No, not 11/9. I took the Indian. That's a Friday.
November.
No, 11th September. Sorry. On 11th.
11th September.
11th is the Friday. There will be difficulty because it's an application date. Apart from Friday, any date.
Yes, I'm obliged to your lordships and lords. I'll just add.
On 9th September.
9th is okay. Take 9th. 9th is fine.
তুমি 9 সেপ্টেম্বরই বললে তো?
9th is fine. 9th is fine.
সকালে না বিকেলে?
9 সেপ্টেম্বর।
Lordship.
কি?
সকালে
My lord, 9th at 2 p.m. I have some.
Morning itself. Morning.
ফাঁকা।
Morning,
Faka.
not 2 p.m. Morning.
Whether it can be fixed on 10th September.
10th is the
Find it out. 10th
10th is the trial court proceedings, lords, on that day.
fixed on.
So just any time before that, your lordships may.
Oh, that is fixed on 10th.
10th. Ninth is okay with me if it suits the learned advocate general, my lords.
Only thing is, my lord, if it is in the first half, my lord. Second half,
I'll be here. I'll come the evening before. I'll be here. No difficulty. At least one way or the other, we'll know, my lords, on 9th itself. If I have to appear.
Well, 9 September at 10:30.
Lordship, please.
Good luck. I hope that.
Nahi, bhai.
Obtain instruction, Mr. Mitro.
I'm grateful, my lords.
এর মধ্যে দিয়ে দাও।
Item number 153.
ফাংশন নাই
Yes, demarcation complete.
I don't.
Which for the state.
Your Lordship, and for the state, Your Lordship, this is the report. Demarcation is not yet complete.
Why?
Your Lordship, SDO has forwarded a letter to the BLRO, Your Lordship, for demarcation, but they have not completed
Where
yet.
is Mr. Das?
My Lord, he was in courtroom number, court
Tell him to come.
750.
I will direct the SDO to appear before me personally.
Piece of orders. My Lord, Passover may be given.
Ask him to come.
My Lord, may I go ahead?
Yes, please call the next matter.
Item number 154.
Lordship, I'm appearing. My Lord, your Lordship, kindly go through your Lordship's last order. My Lord, where your Lordship had called for a status report with regard to the present case, my Lord.
I appear for the state response.
My Lord, I for the private response. Answer.
Yes.
I am, my Lord, a 60-year-old lady. I am being tortured by my son and my daughter-in-law. My Lord, your Lordship is far aware of, my Lord, the jurisdiction. I had not indicated that judgment also, my Lord, as well as, my Lord, the fact that they are at best licensees. I am the absolute owner of that property where I am residing. I am being, my Lord, forced to compel to, my Lord, these kinds of torture on a day-to-day basis. Your Lordship sent it for a mediation. We're hoping that there would be some sense which would prevail that these parties can settle. But, my Lord, in this case, unfortunately, the mediation had failed, which is why your Lordship had called for a report, my Lord. But let them indicate, my Lord, from the report.
Now you are staying out of your residence.
My Lord,
No,
no,
my Lord, they're
I am
staying
staying, no, I am staying in one small room, my Lord, inside my residence. That is where I'm staying. And I am, and he's my only son, and there is a daughter-in-law. These are the two persons, my Lord. It is not that, my Lord, there is.
Both the parties are residing at the same household, my lord.
That is why,
the different household.
Who are they? Are them, my Lord. The son and the daughter-in-law. My Lord, at whose hands I am being tortured. My Lord, now, my Lord, my only respectful submission is that I am staying in one small room over there. I am being facing this entire torture, my Lord, which is happening. I've got various medical ailments, but my son should be taking care of me. But it is not.
See, they can stay at your residence at best as license.
Absolutely.
Now, if you want to evict them, then you initiate a procedure.
I am today, my Lord. Let there be, my Lord, a sharp vigil. Let me be protected. My Lord, your Lordship knows, my Lord. Otherwise, I am, my Lord, being subjected to this.
In that event, I will direct the police authority to
Deeply grateful.
To grant to extend protection if occasions were.
Yes, my Lord. Deeply grateful.
Mediation failed. Nothing.
Mediation has failed.
My Lord, and the report your Lordship had called for, because with regard to our torture,
that was
whether they have indicated in the report, my Lord, that whether I am being subjected to this or not. Now, this is the second aspect I wanted to say. वो judgment देखिए हाँ
Sure. Mr. Das, learned additional government pleader representing state respondents, files a communication dated 24th August 2026 of officer in charge Halishwar police station, and same is taken on record. So copy of the report, copy of the communication dated 24th August 2026, copies are made over to learned advocates representing petitioner and respondent numbers 6 and 7. Next paragraph, Mr. Mukherjee, learned advocate representing petitioner, submits that petitioner is senior citizen and residing at the residence of her husband.
Husband is no longer there. I am the sole owner.
Is residing at her own residence, but is subjected to torture and ill treatment at the instance of respondent number 6 and 7, who are son and daughter-in-law of the petitioner. Taking note of next paragraph, taking note of the fact that petitioner is senior citizen, and it is alleged that he is being tortured and ill-treated by respondent number 6 and 7, concerned officer in charge Halishwar police station. Now, officer in charge Halishwar police station, being respondent number 5, is directed to extend protection to the petitioner if occasions arises. Stop. Next paragraph. The petitioner shall also be at liberty to approach jurisdictional authority under the Maintenance and Welfare of Parents and Senior Citizens Act 2007 in pursuit of remedy. Next paragraph. Writ petition stands disposed of, parties to action solved.
Your Lordship has directed the police to assist us in the situation so arise.
Deeply. Much.
Also, matter item number 153. My lord, 153. My junior has briefed me. Lordship, the demarcation steps have been initiated. I know it has been belatedly done. Lordship,
I have directed the police authorities to provide protection.
No.
And it is being taken such a long time to demarcate the land.
Yes, Lordship, that SDO will not do the demarcation. The demarcation is done by the BLLRO. BLLRO, a communication has been sent to the BLLRO by the SDO to demarcate the land. It was sent on 24th of August after taking all the necessary inputs from the police authorities. That is why it was sent on 24th.
Cannot manage, then tell me if you means your state machinery. I will direct the central force to deploy.
No, it is not going to be required, Lordship.
There is local disturbance.
Kindly grants me 2 weeks.
It appears to me that your SDO is scared of in demarcating the land in question.
Lordship, kindly grants.
It would not have taken such a long time.
Lordship, I will not give any excuse. There has been delay. I will candidly admit to it. Lordship, kindly grants me just 2 more weeks. I will ensure that it is demarcated and I file a report that it has been completed on the next returnable date. Lordship, I bow down.
By this court.
I bow down, Lordship. If it does not happen by the returnable date, Lordship, my Lord may pass any order that my Lord wishes to the extent of calling for the personal appeal.
Because last order was passed on 23rd July, Mr.
23rd.
Then take back your.
My Lord kindly keeps it on record. Kindly keeps it on record, Lordship. It aids me, Lordship. Lordship kindly records the fact that it was
first demarcate and then place.
Lordship, very well, Lordship.
No. At the time of call, Mr. Das, learned additional government pleader representing state respondents, prays for 2 weeks' time to complete demarcation of land in question in terms of the order passed by this court. Stop. Petitioners, respondent number 9 and respondent number 11 to 13 are represented by land advocates. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on Very well. 24th September 2026.
Very
We'll
grateful.
get 3 weeks time.
Very grateful.
But I perceive that local administrative machinery is not
My lord,
uh,
if that is so, lordship, I will
not
myself
bold
make that
enough
prayer.
to take steps, since there might be local tension, in spite of the fact that court has directed police authorities to provide protection or
Lordship.
to extend assistance.
My lord, I will come.
24th September.
Item number 155 and 156. Report আছে? Sir আছে?
156 answer.
রিপোর্টটা 159. The latest report কোনটা?
Yes, who is for the petitioner? Yes, report.
Yes, lordship. This is the report. A FIR has been registered. This is the complaint of
The petitioner has gone to her residence
lordship. That is
as it was directed, because she was in coma, and thereafter after recovery she was staying at the residence of her elder sister.
That is one report regarding the registration of FIR. This is another report, lordship. This is a much more updated report.
No, this is 8 July.
Yes, this is another report. Both the reports I wanted to indicate. The my lord will kindly take
Whether petitioner was taken to her residence.
She is unwilling to go to the residence. That is what the report says at paragraph 3.
At the time of call, no one appears for the petitioner, respondent numbers 4 and 5 and 6. However, state respondents are represented by Mr. Das, learned additional government pleader, who files a communication dated 25th August 2026 of Inspector in Charge, Dongjur Police Station, and same is taken on record. Next paragraph, it is disclosed in the communication dated 25th August 2026 that in spite of attempt made by the police authority to take the petitioner to her own residence, petitioner expressed her unwillingness to go to her residence. Stop. Since it appears, next paragraph, since it appears from the said communication dated 25th August 2026 that at present petitioner is not willing to stay at her residence, no further order need be passed on this writ petition and the writ petition is disposed of. Stop. However, this order shall not preclude the petitioner to take steps in accordance with law by approaching jurisdictional authority under 2013 Act. এক্ষুনি বললাম যে শুনে আছে কি বললাম jurisdictional authority, magistrate, jurisdictional authority under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. Stop. Writ petition stands disposed of. Parties to act on server copy. You take back your previous communication. এইটা কি বলতো পড়ে আছে এখানে এটাতে রেকর্ড করে রেখেছি But there is another writ petition.
Same. 155 and 156 on the same cause of action.
By same petitioner.
Same petitioner?
No.
Not the same petition.
Going on, they had called upon the who are disturbing the peace and tranquility. They had called. Yeah, Alpana Chatterjee.
Alpana Chatterjee আরেকজন বোন
Daughter of the petitioner has filed it.
Yes, the private respondent number 4 in the earlier writ petition. Case and counter case.
Issue. ওখানে নিচে ইউনিটি করে এটা দিয়ে দিতে আর একটা রিট পিটিশন আছে WPA 15495 of 2026 Sonda Chatterjee versus the state of West Bengal others. The writ petition is the writ petition being WPA 15495 of 2026 is also taken up for consideration when no one appears for the petitioner and state respondent. No one appears for the petitioner and respondent number 4. However, state respondents, who is appearing for the state? However, state respondents are represented by learned advocates. Stop. Next paragraph. In view of order passed today, 27th August 2026 in WPA 11546 of 2026, present writ petition being WPA 15495 of 2026 is also disposed of.
Grateful. Item number 157.
There is a service.
Appearing for the Axis Bank added respondent, Your Lordship. Pursuant to previous occasion, we were directed to add, Your Lordship. We have the instruction in this matter. May I please, Lordship?
Today, petitioner has, on behalf of petitioner, accommodation is prayed for. So let me adjourn the matter, come back on a subsequent. At the time of call, accommodation is prayed for on behalf of petitioner. I have a state respondents and respondent, I have a state respondents and additional respondent number 7 are represented by learned advocates. Next slide. Affidavit of service filed on behalf of petitioner is taken on record. Next slide. Acceding to the request made on behalf of petitioner, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 9 September 2026.
Item number 158.
Yes.
And the daughter, Your Lordship, we are for the private respondent. The daughter has been served a copy. At the outset, I would like to bring this fact before Your Lordship's notice that the father has transferred only his share to the daughter. The writ petitioner's share is still in that property.
Writ petitioner's?
The writ petitioner's share is still in that property. Only the father's share has been transferred. There are 5 portions of that property, undivided. Father transfers his share to the daughter, who appears before the SDPO.
Who is the petitioner? Daughter?
The grandmother. The grandmother, the mother of the
representing petitioner.
I am representing the respondent number 7 and 8, the son and the daughter-in-law 6 and 7. 6 and 7.
You are for the petitioner. Grandmother.
Grandmother to enter the property.
Previous date, private respondent.
বলে দেখুন এটা সত্যি করে কি দিতে চাইছে দেখ তাহলে কি দিতে চাইছে দেখ father's portion telling the truth to the court. You are an educated word, you're going to understand what I'm telling. ওটা লাগবে না জেরক্সটা আছে সেটা লাস্ট প্রপার্টটাকে না ওটা লাগছে প্ল্যান ফ্যান লাগবে হ্যাঁ লাস্ট তবে না তোমার ফেভারই আমি বলছি জানি না থাকলে কি করে হবে কি করে দেখাবো it has to reflect somewhere, it has to reflect the record.
Now, you have amended the cost title and served notice upon daughter. Now, what you are submitting with regard to the ownership of the premises in question?
The father's share
The respondent number 6, the father's share has been gifted to the daughter, and the daughter is present.
Then the petitioner has a right to stay at the
Yes, of course. I am not. If your lordship
was
remembers,
put
on
under
the
lock
last
and key.
occasion, I told this to your lordship.
It was put under lock and key, and you submitted
Yes,
that
yes.
the entire premises is owned by the daughter.
I called her. I
Order of
saw.
respondent number 5.
I called her. I took the deed. I saw only the portion of the father has been transferred to the daughter. That is what I am saying as an officer of the court.
Mother has a right to stay there.
Yes, I would just bring one. I would just bring one fact.
Appearing for the state.
Last day somebody was appearing with a report. Today, I suppose.
Nigam Ashish and
No, I am appearing for the respondent.
Yes, and that.
I think he is not
Paramita
present
Hindu.
today.
Where are they?
State is not there.
The state's presence is required because court
On the
will
last
contact
occasion, they have submitted a report.
to take the petitioner to the premises again in terms of the previous order.
Your lordship, just kindly sees your lordship's order dated 29/6 once. I have nothing more to submit. I have already admitted whatever is the fact before your lordship. Your lordship's order dated 29/6 in paragraph 6, whereby your lordship has directed in that order, this was your lordship's order, considering the submissions made on behalf of the parties and taking note of the order dated such and such, court does not find any impediment in directing the concerned police authority to permit the petitioner number 1, that is the mother, to stay at her residence where the respondent number 5 and 6 are residing. This, I think your lordship has to modify, because this is not the place where the respondents are residing. They are residing in a separate accommodation, in a separate house, which belongs completely to the...
Made out to that extent.
Yes, so I just pointed out because I don't want any wrong order to...
They, at the time of passing order, that can be modified to that extent. But where is the state?
After your lordship passed that order, they locked the house and said,
When police went to the premises along with the petitioner, then it was found that the entire house was under lock and key. And it was submitted on behalf of respondent number 5 and 6 on last occasion that the premises is owned by their daughter.
And I also
say he is submitting that that is not the correct state of affairs. Daughter is owner of a portion of the premises.
Yes, correct. Correct.
Which was gifted by respondent number 5.
And
this part was gifted.
This is what I mentioned on the last occasion.
The petitioner's right over the premises in question remains.
So deciding since her husband died, after her husband died, she was residing in that house. Her husband constructed the house. This was the original entrance.
Do one thing, serve a notice upon the learned advocate representing the state, because in their absence, if this order is passed, there will be difficulty to carry out this order.
One thing, my lord, I will photograph your lordship that this was the original.
No, I will not.
No, original entrance.
Yes, yes. Keep it with you for your own understanding.
On the last occasion, I just submitted this. Let me verify and come back. And that is why I have told the truth before your lordship. This is not listed.
There are 3 advocates who appeared for the state and nobody is present today.
My lord, on the first,
তুমি বলে তোমার উপর ইনস্ট্রাকশন নিয়ে নাও, আমরা দেখতেছি না আমরা।
I'll take care of it.
My lord, let's এই কোনটা শুরি পুলিশ যাবে শুধু মাকে শাশুড়িকে গিয়ে ঢুকে, মানে মাকে ঢুকিয়ে দেবে, এর বাইরে তো কোনো কাজ।
Mr. Das, you appeared on 29 June 26. Subsequently, on Asian Dotto and Paramita Mondol appeared.
because my lord will remember I was made the court in charge, so I was appearing in the matters where allotment was not happening. Thereafter allotment happened, then I was told not to appear.
Well, you appear in this matter. Mr. Bhattacharya, allow him to appear.
Yes.
Since he appeared. Matter is taken up for consideration when learned advocate representing respondent number 5 and 6 submits that
আরে এগিয়ে আসো তুমি, এটা দেখি তোকে বলেছে না এগোতে।
additional respondent number 7
তুমি সামনে এসো, তুমি কোথায় দাঁড়াবে, মানে তুমিই সব।
is owner of additional respondent number 7 owns part of premises in question, which was part of premises in question, since share of respondent number 5 was gifted in favor of respondent number 7. Stop.
Because state is more tangible.
It is also submitted that petitioner is mother of respondent number 5.
Yes, mother.
It is also submitted that mother of respondent number 5 has right to stay at the premises in question. Next paragraph. Hence, respond hence, inspector in charge, Shuri police station. Being respondent number 4 is directed to take the petitioner to the premises in question and make arrangements so that petitioner can stay at the said premises. Stop. Petitioner by sending a letter will express her willingness to go to the go to the premises in question, indicating date and time by 7 days from date. Stop. If such letter is submitted by petitioner, in that event, respondent number 4 shall take respondent number 4 shall take necessary steps so that necessary steps enabling the petitioner to stay at the premises in question. Stop. Hearing of this matter stands adjourned for 3 weeks. Stop. List the matter under the same heading for further consideration on 24th September 2026.
Whenever your lordship.
If the house is again on the found unlocked,
Let them come back. Let the police file a report. You have to send an intimation to the inspector in charge of the concerned police station, expressing your willingness that on a particular date and time when you want to go to the premises. That I have recorded in my order.
I would ask the respondent number 5 to physically be present at the time when this is opened. I give that word to your lordship.
Yes.
I would ask that to be done. আমি বলছি তো তোমার
Mother of respondent number 5.
ঘাড় ধরে পাঠাবো তুই যাবে
এন্ট্রান্সটা ওটা করে দিয়েছে
সেটা কি ইনি ডিসাইড করবে ডিপলি অবলাইজড ডিপলি বলছো দাদা এই নাম
Item number 159. 159.
159, I was to come up with my updated report.
My lord, I am for the added respondent de facto complainant before your lordship. Your lordship on the last occasion has added me, my lord, as a party.
Just a minute.
Yes, my lord.
There is there are 2 accused brothers.
Just a minute.
Yes,
Just a minute.
State. আমার রিপোর্ট দেওয়া ছিল, আমারটা বলছি সেটা। আপনি আগের দিন ছিলেন না কেন বলুন? থাকলে এটা জিজ্ঞেস করতেন না।
এটা ডিপার্টমেন্ট থেকে অ্যামেন্ড করাও নেই। Department is directed to amend the constitutional and array application. Applicant being can 1 of 26 additional respondent by 7 days from date. Where is the amendment? আমি বলে দিয়েছিলাম পরিষ্কার করে প্রত্যেকটা ম্যাটারে is not complete.
Oh,
by sending the writ petition to department. There's a lapses. It can be done. Come back after the week.
May I only suggest one thing?
only one thing, my lord, that I'll indicate. We have filed the updated report. 2 brothers are, my lord, arraigned as, my lord, accused. One was already in custody in connection with another criminal case. So there has been a jail interrogation. And so far as, my lord, the other brother is concerned, the petitioner herein,
2 brothers are accused in
in the same case,
in an
in
identical
this
case.
particular case only. Now 35(3) notice, my lord, that has been issued. He has not complied with the 35(3) notice owing to pendency, my lord, and he has cited some health reasons. So there is an inbuilt safeguard. He can comply with the notice. He can comply with the notice. He has already been issued. That is what my
We have
report
not
indicates.
said- What has happened is, Miller, 35(3) notice was given. He had undergone an operation. He said that for this reason he is unable to go. Let them give notice tomorrow. We'll go.
We'll do that.
Why will we avoid?
Cannot pass this order because this my order has not been complied with by the department.
Well, may I say this, subject to your lordship's
I had
correction?
suggested, in fact, for that reason only that in appellate side.
It is generally not done in my court. Somehow it has.
Human, and considering the volume of cases, my lord, at times it happens.
Yes, Mr. Doctor, what you are suggesting?
Well, I was suggesting that the lordship may direct the department to carry out the amendments. In the meantime, the report may be just for our perusal. If a copy of the report can
No, report I cannot. It's an ongoing investigation. Report I cannot hand up. I can hand up as many reports as.
Well, I'm simply adjourning the matter. Let the report be placed on the next date. I'll pass on.
My lord. My lord, may the report be kept on record? Or I can take it back?
Take it back.
Very well.
Hearing of this matter stands adjourned. Since it is found on perusal of record that in terms of the order dated 12th August 2026, department has not amended the cause title of the writ petition, thereby arraying applicant in Can 1 of 2026 as additional respondent. Stop. Let steps be taken by the department in terms of order dated 12 August 2026 immediately. Stop. List the matter under the same heading for further consideration on Thursday next, comma.
My lord, then kindly keep it after 2 weeks, my lord,
September.
so that we can, my lord, at least he can respond to the 35(3), my lord. We'll give another notice, my
Yes,
lord.
Lord, because I am for the de facto
We
complaint.
can
My
come
lord.
up
I
with, my lord, something more updated, my lord, because the investigation, we are yet to interrogate him.
10 September 26.
Grateful, deeply grateful.
But only one thing,
On 10 September. Yes.
only for clarification, I don't think it's required. But on 19th of June, my lord, your lordship was pleased to, my lord, give a protection. I hope that protection continues.
So 35(3) he complies, that is an inbuilt safeguard.
19 June.
19 June, para 7.
Paragraph 7. Then I'm fixing it after
My lord may not. My lord.
after 3 weeks.
3 weeks, my lord, let him comply with it.
Yes.
My lord, may kindly
Lordship,
clarify, my lord, that this will not deter us, my lord, from issuing notices under section
17th
35(3).
September.
My lord, this will not deter us, my lord, from issuing notices under section 35(3), my lord.
My lord,
Let the amendment be.
There has been
and
an.
you indicate the present position, I will consider.
my lord, because we have to, my lord, cooperate. Lordship can understand. I am for the de facto complaint.
No,
Let
it
it
has
be
already,
indicated that.
it has already fallen from Mr. Datto, my lord, that if we serve a notice, yes, tomorrow he will comply. So
Yes, let that.
And you file a further reply
I'll file a
and
further.
give the update. So far the investigation is concerned.
I'll do. Grateful to you, lordship.
I'm grateful. Item number 160.
160, yes.
But I appear for the petitioner.
My lord, I am assisting Mr. Dotto, my
Order
lord,
number 6, man.
in this matter.
Yes.
But on the last occasion,
List
where
provided.
My lord, list was provided, it was indicated.
I'll tell you, Lordship, there is a difficulty with the list. I don't blame them because this list has been given by the Falta PS IC, subject to correction. But we discovered, at least my advocate on record discovered that in connection with another police station, there is another case. So
Against the petitioner.
against the petitioner. Therefore, I was praying, my lord, if your lordship, because I can understand, my lord, the
Superintendent of Police, Diamond Harbour Police.
either superintendent or, my lord, the DI,
Inspector General of
or, my
Police.
lord, the highest of authority.
Generally, court directs if it is within the jurisdiction of
Yes.
Bengal Police,
Yes.
then Deputy Inspector General of Police, Legal West Bengal.
Your lordship, I direct.
Whether he has been made party.
No, he is not a party.
Malad
DIG
can direct
there.
him, Malad. He's not be made a party. Malad can direct him, Malad.
Then I can dispose it of.
Yes,
No,
yes.
no.
No, that was the prayer made on the first day only.
No,
It
no,
was
there are
Arjun
other
Singh,
prayers.
Mr. Oyun Bhattacharya was there.
My lord,
My lord,
caution
I am
of the
appearing
FIR.
online, my lord. I am assisting Mr. Dotto, but no such submission
Prayer
was
D
made by
kindly
me.
have a look, my
Go
lord.
on assisting Mr. Dotto.
But he does not require my
Number one is
assistance, I know
prayer
that.
D. Where number two is, my lord.
Senior is physically present, junior is present virtual.
Yes.
Ma, I'm
do you
sorry, my lord, for
respond?
that.
How do you
My
respond to this? How
Well,
do you
my
respond to
apologies.
this?
Well, my
What
apologies.
sort
but-
of assistance you can extend for presenting better case before this court on behalf of the petitioner?
Well, he does not require any assistance from me, to be very honest. He's so thorough, my lord.
Fortunately,
Just the
all
opportunity I missed to appear before your lordship.
Fortunately, all Bhattacharyas are not as unemployed as I am.
Yes, that is understandable, no doubt.
Where number one is, my lord, as of now, my lord, whatever is the list, where the list has increased. Number one. Number two, my lord, my principal case would be, my lord, this is a case of persecution. With the change in political dispensation, ruling dispensation, my lord, this has happened. Now, number three, my lord, what is very important today is, my lord, we have been robbed of our right of legal representation.
If you want to place your case on the point of seeking quashing, you can place.
Yes.
Because I will not permit you that after furnishing exhaustive list indicating details of criminal prosecutions which are pending against the petitioner.
Yes.
In this writ petition, I will not permit you after I have passed an order in Abhishek Banerjee versus State of West Bengal. Because there I have decided that order is going to be challenged by Mr. Bhattacharya's client before the higher forum, that I know. But the thing is, because stay of operation of the order was prayed for. There I have decided that the disclosures in the writ petition, particulars of FIR, if are disclosed, in that event, the propriety of those FIRs can be gone into, not beyond that. So therefore, even if that is those particulars are disclosed,
yes,
that I will not. This court will not consider or examine propriety of the FIRs, particulars of which are not given in this writ petition or not present in the.
No, I will confine myself to, my lord, in that case, my lord, to the 4 or 5 which I have challenged over here. But, my lord, keeping, my lord, these the reliefs or the prayers confined to the cases mentioned in prayer D, please have a look to, my lord, page number 42.
Taking a different stand from the stand that was taken on the 24th of June.
42.
42. Prayer D. I'll confine myself to that.
Yes.
But my principal submissions are, these 5 or 6 cases are enough to, my lord, demonstrate before this court that, my lord, these cases are filed or initiated out of political vendetta. But that is the final relief that I'll be claiming before my lords. But as of now, my lord, my prayers are, number one, my lord, the entire list of cases be furnished to me. Number two is, what is very, very important is, my lord, we are not getting any legal representation in that court. I cannot engage any advocate over there. The PPO of that court has moved writ petition before your lordship.
But now I am told that
Now there is a new panel. I had indicated that.
and that impasse is not there.
For me, instructions are from elsewhere. I cannot say.
Nowhere pleaded also.
I do not get a right of legal representation. My access to justice has been curtailed. Number 4 is, me and my wife, me and my husband, we have both been taken to somewhere else in Dokhin Dinajpur. We have husband. Acha, I'm so sorry. Only the wife, that is the petitioner, has been removed to Dokhin Dinajpur.
is not in a position to track all matters so far facts are concerned. So many matters. Yes. Yes.
And therefore, Millard, in this situation, Millard, kindly consider, Millard, the case on its merit at the final disposal, your lordship will definitely, Millard, look into the veracity of the case, what relief I am entitled to. But as of now, me and my husband, we must get some legal representation. Now, how can this be ensured? Please consider this, Millard. Article 21 violation, your lordships have held that access to justice is, Millard, part of Article 21. Millard, I cannot engage my lawyer, Millard, this legal aid and all, Millard, they are providing, Millard, lawyers. I do not know in which cases I am in custody, so that I can apply for bail, whatever, Millard, are the other remedy open to me. So therefore, Millard, taking into consideration the entire situation, Millard, the writ court, Millard, has to intervene.
Whether these are the issues you have
No, Millard,
highlighted in this writ petition.
Millard, some of them are there, but Millard,
How these issues can be gone into?
Millard, I am before the constitutional court where I am, Millard, alleging, Millard, infraction of my fundamental right. Your lordships have held that I myself cannot barter away my fundamental right. This is what your lordships have held. Therefore, Millard, whether, Millard, it is pleaded or not, but your lordship has taken judicial notice that the PP is unable to function over there. Therefore,
But subsequently, after the order passed by this court, then the situation.
But Millard, situation has not changed for me. The situation may have changed for the learned advocate.
Appointments are made in the post of PP and other.
But for me, situation has not changed.
Who are the retainers of state government?
Yes. I am, Millard, at the same receiving end.
The submission was that the PP is not being permitted to enter.
No,
Now,
that is in
on
the
being
PP state.
communicated
That is in
that
the
no,
PP
there is a
state.
new panel. There is a new panel.
No new appointments. Now new panel has been passed.
Yes. Now,
So that position is
Millard,
not
the
there.
panel is to represent the state or the prosecution. Panel is not for me.
Yes.
Therefore, please consider, Millard, how can, Millard, my right for access to justice, Millard, can be ensured. I have nowhere to go except the, Millard, writ court. As it is, Millard, the state is against me. This is my case. Right, wrong, Millard, your lordship will decide at the end of the proceeding. Now, kindly see, Millard, prayers H and I. First is, Millard, parroting, Millard. Those are, Millard, somehow stopped, Millard, because of your lordship's observation. Please take prayer each. Please have a look at prayer K. H. But I'm not troubling your lordship with the others, Millard, prayer M, N, and all those.
But Mr. Bhattacharya, petitioner should be permitted to be appropriately represented before the court below.
But, these are, my lord,
If this is the situation,
more in the nature of, my lord.
there is there so far in connection with the case which is required to be fought on behalf of the husband of the petitioner.
But
Millard, page,
Ideal.
just a minute. Millard, appropriate lordship's observation, please take me at my representation. It's a lengthy one. It starts from page 104. But what we are for the present moment dilating, please take, Millard, page 107, paragraph 10. 9 also, 9, 10. Up to 12. A representation. 13 also. The 13 also we should have. Sure, yes, all right.
My instructions are that, my lord,
Keep the case from Diamond Harbour to Alipur.
that has to be done in exercise.
That can be done.
That has to be done, my lord, in exercise of powers, my lord, under the CRPC, my lord.
No, Red Court has the
Court
power.
has the
You can't say Red Court doesn't have
But,
the
my
power.
lord,
If
what,
this is the situation,
what
to
we
ensure representation.
what
on
my
behalf of
instructions
the
are,
petitioner and her husband, shift the case, transfer the case.
my lord, let me come back with instructions, my lord. Let me come back with
Because otherwise,
This
my
is
lord,
followed from your lordship, but
This
my
is the-
instructions are, my lord, that, my lord, it's the Bar Association.
These things continue.
Hmm.
Then there is no other option.
My lord, where is the statement? I'm asking this to myself, that this is continuing even today. My lord, kindly
Very well,
appreciate.
to obtain instruction, come back,
I'll come
whether petitioner will be permitted to be represented appropriately before the court below.
But, my lord, if yes, কবে published হয়েছে?
Otherwise, I will transfer the case
On
from the
7th of August.
Diamond Harbour to.
Yes.
my lord, your lordship
Diamond
may
Harbour.
direct transfer of the case, my lord.
Not on the basis of, my lord, statements made, my lord, from the bar.
Yes, you are the additional advocate general. If you submit before this court and on the next date, petitioner will be appropriately represented, and there will be no hindrance. So far, the situation which is
My lord, my
prevailing in
report
court,
says, my lord, there was no.
court will adjourn the matter and to see that what would be the
Let him apply before the state legal services authority.
No, it is not.
No, no, wait.
Petitioner is
No, no,
not
because
seeking-
what-
Mr. Bhattacharya, petitioner is not seeking any assistance from
I understand,
State Legal Services Authority.
but at that,
Petitioner wants to engage an advocate of his or her choice. Whether he will be permitted to
who is deterring the
represent his
deterring the petitioner, my lord, from engaging, my lord, Mr. Dotto, or, my lord, the other battery of lawyers, my lord. This is just, my lord, it's
That is why there is no allegation in High Court.
it's basically an oath versus oath, my lord. Because, my lord, my lord can record and
that the assistance to be provided by the
I am submitting on
Services Authority.
I am
Question is that whether the petitioner will be permitted to be appropriately represented before the court below or not.
He can.
Suppose Mr. Dotto appears at Diamond Harbour.
Who will prevent Mr.
Whether he
Dotto?
will be permitted.
My lord, my instructions are, my lord, kindly may take note of my instruction in this aspect, that the accused was produced on different occasions, but in none of the times, my lord, the alleged
What is the next date?
stated
When
or
the
complaint of any
accused is
physical or
produced
mental
before the
torture or tormentation. Next date, my lord, I have to give.
My lord, your lordship may, to ensure this, instead of, because I have pleaded this in para 19 onwards of my writ petition, your lordship may kindly call for the records of the case to find out what is the situation over there, so far as these cases
Let
are
me come back with further.
Please call
specific
for the
instructions.
records.
My lord, let me come back with further specific instructions, my lord. An advocate, my lord, he can always appear with an advocate of his choice, my lord.
No, it is the allegation that he is not being permitted to.
My lord, there is no law and order situation, my lord, insofar as the police is concerned.
It is his or her right to be appropriate.
My lord, insofar as the police is concerned, my lord, there is a report that there was
specific representation come to say
there was
page 107, paragraph 9 and 10.
And there's no reply to this as of now.
So read paragraph 9, Mr. Bhattacharya.
yes.
That situation cannot prevail. If this situation prevails, then the cases are required to be transferred to some other court.
But my representation is addressed to the
No, he says that he had addressed it to the NHRC also. That
You
there were
can understand that what is the purport of this.
that there were several advocates who were approached, but they expressed their unwillingness. So that is what has happened. But what can, my lord, the police do, my lord, if he says so? If Mr. Dotto wants to go, my lord, he's most welcome to go. There is
Family members of my husband have been virtually rendered helpless.
Yes, yes,
helpless in
yes.
securing legal representation of their choice.
Yes, but thereafter, several advocates who were approached for representing my husband either expressed their inability to appear or were unwilling to accept engagement in view of the prevailing atmosphere.
Read the next para. Para 10, read para 11. A specific allegation.
Yeah, that person
may be a very bad person.
No, but legal
That
right
does
to
not
legal
mean-
representation, my lord, is
Yes, that
definitely.
how that can be curtailed.
My lord, if Mr. Datta wants to appear or anyone wants to appear, my lord, there will be no law and order, my lord. Regarding law and order, there is no complaint. So, my lord has also appreciated, my lord, from the statements contained in that particular representation also, it is not law and order situation. Let them engage anyone.
Next date fixed.
Next date কবে আছে? Here we have challenged a few FIRs.
This is the problem.
What is the next date fixed so that I can call for a report whether the petitioner was permitted to be represented or not.
But I was only playing this, Miller. Please call for the records or at least the order sheet.
But tell me what is the next date?
But actually, there are so many cases, Miller, that there may not be a common next date.
So keeps it after three weeks. I'll come back with a report.
What would be the first date amongst these prosecutions?
Problem is both are in custody. Petitioner has been shifted to Dokhin Dinajpur. The husband is again in custody. So, Wait, for this purpose, kindly keep it as to be mentioned or whatever, Miller, tomorrow or day after tomorrow. Tomorrow or the Monday.
We'll come back Monday.
Or my lord can call for a report, my lord. I can come up with a further report.
Elicit from Mr. Datta that what will be the next.
Next.
I'll fix the matter after that date and I will call and I will consider the submissions of the parties, especially the petitioner, whether petitioner was permitted to be represented.
I may only kindly appreciate the statements with which, my lord, Mr. Datta comments his arguments today. That the PP is not being permitted to enter inside the court premises. But there is a new panel. There is a new panel, my lord. How can, my lord, the PP not being permitted?
In two matters, this court.
The PP not being permitted.
Subsequently, the situation has been changed.
Yes.
But it may so happen because the accused persons, political accused persons, are facing difficulties at many places. So therefore, if this happens in court premises as a result whereof petitioner is not being appropriately represented, that is a serious allegation.
No, but I have taken your lordship, my lord, through para 9 of that representation. It is not a case that illegally or person
take steps, ensure that the proper representation can
but
be made.
if a gentleman who is a lawyer,
If arrangement is made on behalf of the petitioner to be represented before the court, then whether this can be effected or not, and
but it
whether
observes
there is
that,
a
my
proper
lord.
representation,
But it observes that.
be ascertained from the submissions made on behalf of the respective
But
parties on the
it
next day.
observes that. But just for an example, my lord, if my lord, someone from the ruling dispensation, just for illustration, my lord, someone from the ruling dispensation, my lord, approaches my learned senior friend, my lord, to file a petition against, my lord, a party which is in opposition. My learned friend has the discretion not to accept the brief. So what can an individual lawyer, my lord, if an individual lawyer, that is what exactly para 9 says.
No, proper atmosphere has to be provided.
Atmosphere is proper, my lord. By
advocate can represent the petitioner.
but the atmosphere, my lord, can record the atmosphere is proper. He is not saying at all that there is a chaos ongoing inside the court premises. He says that lawyers refrain. We approach certain lawyers, they refrain. At the most, they can make a representation to the bar council that I had approached for legal assistance before this particular advocate. He has refused. But what can the police do, my lord? It's the question I'm asking to myself. Mr. Datta intends to go, my lord. He's most welcome to go. We'll ensure, my lord, that, my lord, there is complete safety and security because there is no law and order situation, my lord, prevailing as of date.
But I have not come here for the safety security of the advocate.
It will keep
Come
changing.
here
Stand will keep on prevaricating.
to ensure that the petitioner gets a legal representation of his choice.
Engage a lawyer. Get a lawyer.
That is what will at paragraph 11 of my representation.
Para 9 before that.
Para 9 is not the end of the representation.
Para 9 ei to.
Milord, may I say this, Milord, subject to your Lordship's permission? Please keep it on Monday or Tuesday. Please call for only the order sheets of these 6 cases. Only order sheets. Or if your Lordship considers, Milord, granting me this liberty, very difficult to make this prayer, but still consider it, that we'll apply for certified copy. Anybody would apply. The certified copy would be handed up to us by a day or two.
We will let those orders be placed before me. Calling records will not will create difficulty so far. Next proceedings are dates are concerned. That I do not want. But Mr. Bhattacharya, place orders passed by the court before this.
But I'll do that. But kindly gives me some time, and I'll come up with the orders.
The order only করতে গেলে
আনবো আমি ওখান থেকে আমার রেকর্ডের থেকে
how can you get the access to
সার্টিফাইড কপি তোলাবো আর কি করবো
হ্যাঁ সার্টিফাইড কপি তুললে
ইস্যু করতে দেবেন Mr. Datta will not let me do anything. Whatever he suggested, Mr. Datta will come up with a new point.
No.
Mr.
I
Bhattacharya
just
is
wanted
safer.
to make him aware
Why
that
he is online.
he's not appearing for the judiciary. He's appearing for the administration. How can he have access
I can
to
access.
the
I can,
to
no,
the
no. I
court
can get
records?
this. I can get
Of
the
course.
certified copies.
He can get certified copies.
So, আর কি আনবো?
You cannot have access.
No, I can get the certified copies. That's what I can do, my lord. Get the certified copies.
But in all these cases, the order sheets may be placed. Either your Lordship directs them to the district judge to place it, or my learned friend can.
Or, my lord, let them suggest the name of a learned lawyer they have engaged, and let us, my lord, report to your lordship whether he was prevented or not. Let them do that. These are all wild allegations. These are all wild allegations.
Yes, may Mr. Datta supply the name of the learned
Yes.
who is representing the petitioner and her husband, so that an appropriate arrangement can be made.
Yes.
There will be no disturbance on the date the learned advocate will represent the petitioner. That can be done.
But I'll take instruction.
No, let them, my lord. I am volunteering. But today morning, while coming to the court, I receive an email. That my lord has passed an order, my lord, regarding that rally of the political meeting of Trinamool Chhatra Parishad. The police has committed contempt. They will mention.
Matter is heard in presence of the learned advocates
No,
representing
এইসব
the petitioner and state
এগুলো
prosecutor.
নতুন রকমের কন্টেম্পট না
Mr.
মেনশন
Datta
করবে বলে
has
তাহলে মেনশনিং এর নোটিসে হয়ে গেছে
praise for
মেনশনিং এর নোটিসে পুলিশ আমার গেল
supply of exhaustive list of pending criminal prosecutions against the petitioner or husband. Criminal prosecution.
Petitioner and husband and her husband. Most of the cases are against the husband. She has also been
list of criminal prosecutions pending against exhaustive list of criminal prosecutions pending against the petitioner and their husband. Stop. Deputy Inspector General of Police within bracket Bengal, West Bengal is directed to forward is directed to intimate petitioner list of criminal prosecutions pending against the petitioner and her husband as on date by fortnight from date.
Do that, my lord.
Next paragraph, leave is granted to the learned advocate for the petitioner to amend the cause title and add Deputy Inspector General of Police Legal West Bengal as additional respondent. Stop. However, service of notice upon additional respondents stands dispensed with since state respondents are represented by learned additional advocate general. Next paragraph, it is also alleged on behalf of petitioner that petitioner and her husband are not being appropriately represented before court below on the date matters are fixed for consideration. Stop. Consideration by the disturbance by the intimidation and threat perpetrated within the court premises.
But I dispute that very seriously.
Court premises. Stop. Mr. Learned advocate for the petitioner shall intimate names of learned advocates who will represent the petitioner and her husband before the court below by.
May I interrupt, Milord? I'm told, Milord, the name can be provided now itself. Name of the learned advocate.
That is not required. You intimate to the additional advocate, he will take steps. To the court below, কি বলছিলাম?
আপনি চলে যান না আপনি চলে যান না ভাবনা করতে
By first September 2026. Stop. Concerned state respondents shall take necessary steps which will ensure appropriate atmosphere in the court premises. On the dates, matters to be taken up by the court below, which will facilitate learned advocate / advocates of the petitioner and her husband to represent their respective clients.
So this would
Madam,
include
kindly-
all legal activities.
Madam, kindly-
Filing work, etc.
Madam, kindly record, my lord, that I am disputing, my lord, seriously disputing this particular submission that the law and order situation in the court premises, my lord, is not
It
convincing.
needs to be recorded here
administration
that
has
the
not
allegation
disputed
made by the made on behalf of the petitioner regarding threat and intimidation by within the court premises on the dates matters are fixed relating on the date matters are fixed relating to the petitioner and her husband is disputed.
Grateful to your lordship.
But only for clarification only, Miller, the learned advocate will be allowed to undertake all kinds of activities like filing vakalatnama applications, bail applications, whatever is
That
required.
is not
Just-
their case also in the
It requires to
representation.
be recorded, Mr. Dotto. I have directed on.
I personally feel not required, but the picture which is given to me is somewhat is very.
Not reflected from the, not borne out from the records though.
Ultimately, if you if it is found that no, you are not being represented, then court will transfer the case to
That's always there.
to some other place.
Miller, the
Acha, list the matter under the same heading for further consideration on. ওটা fortnight বললাম না?
দেখি DIG লিখতে বলে
17 September 2026
the amendments are to be carried out by advocate on record,
by the department.
but it has gone down as advocate on record, subject to correction. Today's order that my lord has been pleased to dictate.
No, I have not direct.
My lord was
No,
pleased-
the DIG legal, my lord, has implemented, my lord.
not the previous day's order, my lord. Now the order which your lordship has dictated.
Yes, that will be by the advocate on record.
DIG legal.
In course of this day, Deputy Inspector General of Police, West Bengal. Deputy Inspector General of Police,
Legal.
Legal, West Bengal.
West Bengal. Grateful. Grateful.
Keep your blessing.
এটা amendment করে দেবেন।
I am mixing up with the previous matter. Directing department to amend the costing. Yes.
Item number 161.
Getting my lord the suspicious death of my son.
To appear on behalf of the private respondents. এটা অন্য আপনার নামটা ভাস্করটার নামটা অ্যাড করে দিন। এটা দেখান। Yes.
My lord, I have a report. I can understand what the writ petitioner must be going through losing a son. Lordship, however, what she had complained of was that there was a criminal conspiracy which was hatched by the private respondent, who was the daughter-in-law of the writ petitioner, to murder the son of the petitioner. This was apparently done by way of an accident. That was her allegation. This was done by way of a sand-laden truck which crashed into the car of the petitioner while it was stationary at a dhaba. Lordship, investigation was carried on that page. Inquiry regarding the allegations raised in the writ petition. Accordingly, the writ petitioner was asked to produce whatever relevant documents that she may have, based on which she has come to make such an allegation. However, she could not provide it. This is also true that the private respondent was also called by the inquiry officer. She also did not appear and to answer the questions of the inquiry officer. What she had informed over telephone to the inquiry officer was that the amounts of money, which was around 11.5 lakh rupees and certain gold ornaments, were part of her Stridhan articles. That is why she had taken them away. Now, this is what the situation is pursuant to since it was a case of accident, or rather a case of vehicular thing. So a FIR was registered. A charge sheet has been submitted in the FIR, making the driver of the charge sheeting the driver of the vehicle which had crashed into the vehicle of the son of the writ petitioner. This is the present situation. Charge sheet has been filed against Bapi Maiti. It was filed on 27th of August 2025.
No, my lord,
Lordship, I beg to
one-
appeal on with the private respondent, Lordship.
But the one-
Kindly draw your attention to one point.
Charge sheet is filed, then what remains?
no, my lord, what my line of is submitting that it was a sand-loaded truck, but in the FIR it was a Bolero pickup, and that I could found from the
That
FIR.
is her allegation.
That is the allegation of the daughter-in-law.
It's a conspiracy. According to you, it's a
According to me, my lord, that is a conspiracy. My lord, with regard to my lord taking out this gold ornaments and others.
Tomorrow, let it retain its position. Take it back, Mr. Das. File it tomorrow.
পরীক্ষা তারপর